Hmm? 30? Hmm. Okay. This is the matter before any other court. After vacation. Requisition has not come. It will come. No, unless the other side is not there, they won't be informed. No? Why was it not listed? चलेगा। This matter tomorrow along with WBC number. Order to silence. We'll see when the matter reaches next. And so the learned counsel submits that the reputation has become infructuous and accordingly would not like to pursue the instant reputation. Accordingly, in that view of the matter, the reputation stands closed. On withdrawal, interim orders if any stand. What is this? So what? Now, why should I entertain this order? Where is the order in original? It is dated 13/2/2025. Why should we entertain this? Understood. My question is, why should I entertain after 2 years, 1 year? No. So what? That those people came early. Earlier in that case, notice was issued by a coordinate bench. That is why. But I'm not going to issue notice. You have a time period of filing an appeal within 120 days. Why haven't you filed? No. No. No, I am not going to look into it. No, absolutely no. Because of the fact that why have you approached this court after 1.5 years? I'm told by Justice Chaudhary has passed an order in that regard, a judgment. Where you need to say this. We don't know. I'm not going to entertain this type of thing because it is you just what is the petition? Sorry, what is the petition? Although the interface of the human principles of health, writ petition can certainly not be exercised when invoked to undermine the defeat of the held High Court in exercise of self when right or liability is created under statute by so and so. High Court will not normally permit to bypass the door here. Health delay cannot be condoned in any appeal prepared after the aggregate. Appellate is not empowered to condone the delay in filing an appeal. Further, health complete mechanism is provided under the year. The mechanism alone has to be followed. Which petition not maintainable as would defeat here. Lastly, appellant in question may have an arguable on merits have and can have no bearing on the justification of not filing the appeal within a statutory period. High Court erroneously took this as a reason to exercise jurisdiction despite the statutory appeal being time-barred. Constitution, when complete appeal is provided under so and so, so and so. That's over. So what? You have to, no, now you have to show me. A violation of law is different. You have to show me that there is no jurisdiction to me. Then only I can. Otherwise, no. No, there's a difference. No, Mr. Jha, there's a difference between no jurisdiction and a jurisdiction and the order has been passed illegally. No, I'm not. This is covered by judgment by the Supreme Court. Because you cannot wake up one fine morning. In 2025, this order was passed on 13/2/2025. You approached this court sometime in the year 2026 by filing the writ petition. You have to be careful on this. You can't just pick up from somebody. So what? Because that judgment was passed Mr. Counsel, kindly appreciate. That judgment which was passed earlier in the case of Catalyst, that was a judgment passed in the year 2024. And 2024, immediately they have moved on the basis thereof. Now, on the last occasion, you have challenged it at a later stage, but as there was an issue, notice was issued by the coordinate bench, I did not insist on that. But this is not the case by which I am going to do it. Not really. We dismiss it. No. No. Dismiss, no? Huh? Should I give you a notice? No. Cost. Cost, you have spoiled almost 15 minutes of this course. I'm not satisfied. Huh? Okay. Heard Mr. N.N. Jha, the learned counsel, appearing on behalf of the petitioner, and Mr. B. Chaudhary, the learned counsel, who appears on behalf of the respondent numbers 1, 2, and 3. The present proceedings have been initiated challenging the order dated 13/2/2025, passed by the respondent number 3 under section 73(9) of the Assam Goods and Service Tax Act 2017. Mr. B. Chaudhary, the learned counsel, appearing on behalf of the petition Finance and Taxation Department of the Government of Assam, raised a preliminary objection as regards the maintainability of the writ petition on the issue as to whether the writ petition can be entertained after the period of limitation for filing the statutory appeal being over. In that regard, he has referred to the judgment of the Supreme Court in the case of Assistant Commissioner (CP) LPU Akinada and others versus GlaxoSmithKline Consumer Healthcare Limited, reported in 2020, 19 SEC 681. It is the opinion of this court that it is the prima facie opinion of this court that it is only when a case comes within the ambit of no jurisdiction of the authority, then only the writ court can exercise jurisdiction. From the pleadings to the effect, pleadings of the writ petition, it does not appear that such a plea has been taken. Mr. N. the learned counsel, appearing on behalf of the petitioner, therefore submits that he may be permitted to file an additional affidavit in that regard. List the matter when you want the dismissal. Any date? Let the matter be listed after the additional affidavit is filed. Hmm. Correction of? Where? Wait. Then? You are a legal aid counsel. You are a legal aid counsel. Then no source of income. How are they affording you? Where is the second wife? Hmm? Hmm. Now that I see. The name of the husband and wife, two names. But isn't this a bit strange to have two names? Okay, now this person was a Bauri. He will be, I think, a Marwari fellow. Bauri also. No, not you. The person concerned, your husband, he's also T tribe. Bauri. So they can marry twice. Oh, your name is different, Bauri. B-A-O. The name is Baori. You have put the Marwari Bauri name. Yeah. Mr. Gogoi, kindly see annexure 1. Actually, this is the Bauri. You see this? Yeah, husband's name is Aniruddha Bauri. Hmm? Hmm. No, birth certificate, I think, of the son. Son. So you see the husband's name is there. Yeah, but they have now put this. This is a, otherwise it is for the Marwari community. They have this Bawri, and you have made him as a party as Bauri. Either this is false. Either page 17 is false or your petition is false, isn't it? How do I know? Where's your Aadhaar card? Aadhaar card. Then, and this is another name, Director of Health Service. This is Bawari, and this is death certificate is Bawri. Birth certificate is Baori. How is it possible? Please me. Not satisfied. We should issue notice or not, Mr. Gugoi? Because you see, how do this court look into this aspect as to who is the wife, proper wife? Where's your marriage certificate? Then, how's your first wife? Everywhere you have a death certificate you want, you have a birth certificate you have, but you don't have a marriage certificate. When did you get married? Hmm? They reside here. You reside here. Huh? How will you? Okay. Chalo. Issue notice making it returnable on 17th of August 2026. Mr. So-and-so, B. Gugoi, the learned additional advocate general, who is also the standing counsel of the Health and Family Welfare Department, accepts notice on behalf of respondent number 2 and 3. Extra copies of the resolution be furnished during the course of the day. As regards the respondent number 1 and 4, the petitioner is directed to take steps by way of speed post by tomorrow. The case of the petitioner herein is that the petitioner is the first wife of one Aniruddha Bauri, since deceased. During the lifetime of her husband, he used to reside with another one. Na? He used to reside with the other one. He, during the lifetime of the petition of late Aniruddha Bauri, on account of matrimonial disputes, they were residing separately. Kusto. The grievance of the petitioner herein is that there is it is the further case of the petitioner that though there were matrimonial disputes, but there was no divorce. However, upon the death of late Aniruddha Bauri, the director, the Department of Health and Family Welfare have issued the death certificate of late Aniruddha Bauri by putting the name of the petitioner as well as one Sumi Bauri as wives of late Aniruddha Bauri. The further case of the petitioner is that a representation was submitted before the Superintendent Gauhati Medical College Hospital on 8/12/2025, but the same have not been considered. It is under such circumstances the petitioner is before this court. Taking into account the respondents herein are directed to bring on record their stand by filing the affidavits. What is this? Registration cancelled. When? Why are you approaching so late? Huh? Why?
Lordship, my business suffered huge financial loss because of which I could not file return for more than 6 months, and as a result of which a notice was issued. But due to
No, notice was issued. Did you receive the notice?
notice was sent through a portal that came to my knowledge very later, Your
You
Lordship.
don't know how to operate the
No, Your
portal.
Lordship, my engaged CA accountant is engaged for that purpose. And since I was a contractor again under the Jan Jiva mission, Your Lordship.
What contractor?
I was a contractor under the Jan Jiva mission, where the government has stopped the work, and after which I suffered huge loss, and so that I could not focus on my business. My business suffered huge loss. Later on, and return could not be filed on time, and as a result of which my GST was cancelled, Your Lordship.
Yeah, was cancelled.
Yes, Your Lordship. So motor cancelled.
Where have you mentioned this?
Paragraph number 7.
Huh?
Paragraph number 7 of my writ petition. Case number 7.
Page?
Page 7, paragraph number 7. Otherwise, my return is nil, Your Lordship.
Where have you mentioned that you came to learn?
Paragraph number 8. With the
Huh?
notice was uploaded on the paragraph number 8. Relevant portion is paragraph number 8. Notice was only
How
uploaded.
did you come to know?
Later on, when I went to file the return, I saw that the
Why did you file the return?
recently, Your Lordship.
Why?
Recently, Your Lordship. In the year 2026, when I went to
Why
file.
did you file the return?
Last return was filed, Your
You have no money.
Later
That
on,
is your basic religion.
now, Lordship, I intend to restart my business. And that could
Huh?
not be filed. Return could not be filed due to standstill of the project. I have suffered huge loss, Your Lordship. Thereafter, Lordship, now
The return of the year 2024,
2023
September
September.
2023,
Last
24, was filed in the month of on 23 itself.
Yes, Lordship.
Where have you started filing of a return? You have not mentioned anything. We cannot allow this type of petition.
Last return was filed in 19/10/2023, Your Lordship, for the month of September. Thereafter, return could not be filed, and subsequently in the month of July 2024, my registration was cancelled. Later on, Your Lordship, when I visited the portal for the purpose of filing my return, I saw that GST was cancelled. Thereafter, I approached the competent authority. They
Why
said
did you visit the portal after 2 years?
that is a problem, Your Lordship.
Why?
Due to sudden instance.
Where is your statement? That you, why did you approach the portal? Hmm? Why? And you verbally went to the respondent office out there and said that what has happened? Have you written a letter to them?
No, Lordship, I went there for the purpose of inquiry. Then they have stated that.
You say that the petitioner visited the office and mentioned about the reason for not filing. Whom did you meet?
And I approached the competent authority, Your
Who?
Lordship. The respondent number. The respondent number 2. The principal.
At the respondent number 2.
Yes, Your Lordship. GST Bhavan, Your Lordship. I inquired about.
At the respondent number 2. The principal commissioner GST.
Yes,
You met him.
I visited the office, Your Lordship.
No, you said that. Kindly see paragraph 7, 9. The petitioner visited the office of the respondent authorities and mentioned about the reason for not filing and also requested them to allow to pay the arrears and restore. The petitioner also updated the returns and the respondent updated returns up to so and so by year. Now this statement you must have copied and pasted from some other petition. Obviously. Now, if you say that you have filed it in of September 2024, updated up to September year, and you visited, this must have you visited in 2026.
26.
Then where is your updated returns from till September 2024? September 2024, your updated return is of 2023.
Last,
Why you are making this false statement out here?
last return was filed on 27.
So what is, how do you take,
September.
how do you tackle with these statements? Paragraph 9, kindly see this. Where? See, the petitioner visited the office. Have you got it? Read it. Paragraph 9.
With the petitioner, office of the respondent authorities and mentioned about the reason of non-filing of return and requested to allow them to pay the arrears and restore the registration number. However, the same was not considered.
So you visited in 2026.
Yes.
Then the petitioner also filed updated returns and respondents were updated up to so and so.
Yes.
When? This must have happened in 2026, but your return is of 2023. So this is a false statement.
The last return was
On
filed
account of the
23.
false statement, I think we should dismiss your petition.
No,
You are
Lordship.
not entitled to all this.
No, Lordship. Last return was
Oh,
23.
I think
I
this
have
is a case of you have copied and pasted.
no, Lordship. I have mentioned that in my petition that last return was filed
Okay, now tell
23.
me. I will allow your petition issue notice provided you help. Tell me something on GST. Then only. What is the course of action to be taken now? I will allow you. Now what will happen to this?
Lordship,
These
if
returns and all, what will
we
happen?
have to pay the up-to-date returns. Moreover, if any penalty is imposed upon me, that I have to pay the source.
Penalty is different. But what about the assessment? You have not submitted your assessment return under
I will submit.
GST, 9 GST you have not submitted.
No,
Then
I will submit, Your Lordship, once it is written.
Then, well, means there is no self-assessment done. So you take action, penalize, and non-filing amounts to also what? It's a, there's a Supreme Court judgment. It amounts to fraud being committed, willful suppression of facts. And as such, you have to have the penalty. Put these people to jail also. It's a case under 132. We passed that order to put you in jail.
No, Lordship.
Yes, this is what you have entitled.
If any mistake is
No,
committed, I
it's
am
a very
able.
serious infraction.
I will-
You have made
I
first
will-
making
I-
a false statement
No,
before
Your
the score.
Lordship. This not a false statement intentionally made, Your Lordship.
They intentionally, why you are
Your-
copying, pasting this type of writ petition? This is a copy paste writ petition. Everybody is saying the same thing.
Lordship, it is not drafted
And
by
these petitions were made in the year 2024. And now in 2026, without seeing the facts, you are repeating.
no,
And
Lordship.
this is why the problem has arisen.
I'm so sorry, Your Lordship. Kindly,
Take
I-
your penalty, 132. Put
Kindly,
them to
Your
behind jail.
no,
And they
Lordship.
are not entitled even to bail also.
No, Lordship. Kindly,
Okay. Section 132.
kindly, Lordship.
One.
I
Serious.
will file all the returns, Your Lordship. Kindly.
Allow koribo, huh?
I'm deeply upset.
What is it?
But petitioner is a tea garden. Uh, there is some dispute between workers and management. Some of the employees were absent without any reason. So the management is so opposed to them. Thereafter, there is some difficulty in operating the management if they are opposing it. So there is subsequent development in this matter. We have already opposed earlier we have opposed the deputy commissioner, district administration, and as per information,
Now you are not in a position to enter.
no man,
Then
they are creating
who is interfering? Who is interfering?
Your
Assam Samosdur.
yes, Your Honor.
They are interfering.
Yes. Now there was a meeting held recently with the management, the district administration, and the worker union. Your Honor.
Hmm.
So I'm praying for adjournment for short adjournment.
Why?
There is some upgrade, development in this matter.
You have not paid money.
No, we have already paid.
Huh?
There's no pending.
Complain against owner management of you are not paying the provident fund and
My lord, we have
Anyway, at the request of the learned counsel, appearing on behalf of the petitioner, matter stands adjourned to be listed on 17th of July.
obliged.
Sound freeze.
Yes, sir.
Why?
Lordship, there is.
How
some
much
cyber-
amount?
The disputed amount is not informed to me, Your Lordship. The amount we have visited the
You are
bank,
appearing for whom?
another bank. Sir.
You are a standing counsel. You are a standing counsel. Then how are you appearing?
The copy I have
You are not on
taken after
caveat?
Instruction.
Huh?
After instruction, I have taken the copy.
So you have instructions?
Yes.
What is the instruction?
Your Lordship, over phone, I have taken the instruction when the copy was served to me.
What is the instruction?
That to receive the copy.
That is different, but what is the instruction?
Oh, that in regarding to the matter.
Ah,
Your Lordship, I have given them the petition, but due to the transfer month, the manager has been transferred, so I could not able to collect the instructions.
when was it free?
On 19.
Huh?
19, not free. May 2026. Lord.
May
2020, this year, 2026 of May.
20. You don't have the date.
Date, Your Lordship, that it's not been mentioned, Your Lordship. We have just been intimated orally that the account has been present pursuant to a cyber complaint, Your Lordship.
Where is the document?
Para 7 and 8 we have mentioned, Your
How
Lordship.
much amount you are having?
Your Lordship, it's a meager amount, Your Lordship, but the account is important because it's operational account.
Huh?
The account, we do not have much amount, Lordship, but 10,000.
Having a balance of 10,432, but page number 21.
Where are you basis? You are saying that it has been.
It para 7 and 8, Your Lordship.
No, where's your information given by them
No,
that it has been frozen?
it has been intimated orally, Your Lordship, by the manager.
That means are you are you using these bank accounts?
No, we have not been, it has been frozen. Lordship, may kindly see para 7 and 8, your lordship. Page number 4, your lordship.
No, I won't go by the paras. Can't make this. From Haryana, Goregaon amount 10,500. Okay. Issue notice making it returnable on Union? No Union. Issue notice making it returnable on 27th of July 2026. Pusta. None has appeared on behalf of the Union respondent number 1, that is the Union of India. However, respondent number 2 is being represented by Mr. M. Sharma. Mr. Extra copy of the requisition is served upon Mr. M. Sharma during the course of the day. As regards the respondent number 1, a copy of the requisition be served upon Mr. R.K. Dev to Mr. H. Gupta, the learned CGC. The petitioner herein has a bank account, savings bank account, has a savings bank account bearing account number 11030-431-6150, which is maintained in the Morigaon branch of the respondent number 2. The petitioner was informed in the month of May 2026 that on account of certain information received, the petitioner's account had been frozen. It is under such circumstances the petitioner has approached this court by filing the present writ petition, inasmuch as the petitioner is at present not being able to use the said savings bank account. The respondents, more particularly the respondent number 2, shall produce the instructions on the next date as to why the petitioner's bank account have been put into freeze. Have been put.
Check. Is that pertaining to revocation of cancellation of GST registration?
What?
Revocation of cancellation of GST registration, my lord.
Vocation of
Cancellation of GST registration. GST registration,
cancelled.
my lord.
Why? When was it cancelled?
By 2026, my order was passed.
Why haven't you
Number
filed your
30.
reply? Huh? Why you are referring to all these things?
About my person.
Huh?
The Impune order passed in 5/2020, page number 30, my lord. And we have filed this last.
The order was passed on 5/2/2026. Notice issued on 13/8/2026. What is this?
24, my lord.
24, lordship.
13.
That is why 13/8/2024 and you cancel on 5/2/2026.
Lordship.
How is it possible? Therefore, heard Miss So and so, the learned counsel appearing on behalf of the petitioner, and Mr. K. Jain, who appears on behalf of the respondent numbers
Lordship.
2 and 3. Yeah. So and so for respondent number 1. The petitioner herein has approached this court challenging the order of cancellation of the registration dated 5/2/2026. It is the case of the petitioner that there was no show cause notice issued to the petitioner. There's no show cause notice issued to the petitioner against the said cancellation. In fact, the show cause notice which have been referred to in the order of cancellation of the registration dated 5/2/2026 is almost 1.5 years before. First, this court had duly taken note of the 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 materials on record show that the petitioner herein is a partnership firm and was granted registration with effect from 12/9/2019, bearing GSTIN number, a registration number, এই to page annexure 1 of the report লেখা আছে দেই, আরে ভুল এটা করে দিস। Just on the ground that the petitioner did not submit the returns in terms with section 39 of the Central Goods and Service Tax Act 2017. A show cause notice was issued on 13/8/2024 in the portal, isn't it? Just be that as it may, the respondent number 3, the respondent number 3, thereupon did not take any action. Recently, the petitioner could come to learn upon taking steps for filing of the returns that the petitioner's registration was cancelled on 5/2/2026 on the basis of a show cause notice dated 13/8/2024. It is under such circumstances the petitioner is before this court. The learned counsel appearing on behalf of the petitioner submits that a perusal of section 29 of the Central Goods and Service Tax Act 2017 though permits the proper officer to cancel the registration, but before doing so, the proper officer has to give the petitioner an opportunity of being heard. The land council submitted that even assuming for argument's sake, the notice dated 13/8/2024 can be said to be a notice properly issued. Then also, not taking action on the said for a period of more than 1.5 years, for a period of 18 months, and all of a sudden taking action on 5/2/2026 cannot be said to be an action based upon the said show cause notice. This court have also heard Mr. K.J. in the learned counsel appearing on behalf of the petitioner's respondents and have given an anxious consideration to the submissions so made by the learned counsels appearing on behalf of the parties, and have also, as well as the materials on record. From a perusal of the materials on record, it is apparent that the show cause notice was issued on 13/8/2024. Thereupon, the proper officer did not take any steps. The records further revealed that all of a sudden, on 5/2/2026, steps were being taken, the registration was cancelled. The cancellation of the registration in the manner, in such a manner, cannot be said to be in compliance with Section 29 to the proviso to Section 29(2) of the Act of 2017, inasmuch as the said notice, which was issued on 13/8/2024, have become redundant in view of no actions being taken. Further to that, for the period from 13/8/2024 till 5/2/2026, there has been 2 financial years. And there were various other intervening events pertaining to which required filing of returns. These aspects were not taken into consideration by the respondent number 3. And as such, it is the opinion of this court that the impugned order of cancellation dated 5/2/2026 is not only in conformity, it is not in conformity with the proviso to Section 29(2) of the Act of 2017, but also appears to be unfair and unjust. Accordingly, the impugned order of cancellation in order for cancellation of the registration dated 5/2/2026 is set aside and quashed. Next. Before parting with the record, this court, however, observes that the setting aside of the order for cancellation of the registration dated 5/2/2026 shall not bar the proper officer to initiate action against the petitioner in the circumstance it is found that in the circumstance materials are available for initiating action under Section 29, if so advised. The petitioners, it is further observed that the interference with the order of cancellation dated 5/2/2026 shall not act in any manner, shall not be construed to be in any form a waiver on the part of the petitioner not to comply with the terms of the Act of 2007. Yes, Mr. Day.
May please the Lord.
GMC,
Yes.
what has happened?
Bill has been raised, you challenging the bills.
What bill?
Advertisement. An advertisement are there without permission from the GMC.
What is he challenging?
My
Withdraw the illegal demand notice.
illegally pulling down and removing the unipoles, which was
Huh?
prospect. Unipoles hoarding my lord,
Ah,
in the middle of the my lord, the court.
ah.
And that kindly see Annexer P, page 30. This is the application, my lord, filed by the petitioner before the chief engineer for issuing the NOC for installation of unipoles in various parts of the city.
Hmm.
And accordingly, chief engineer written to the executive engineer for feasibility report.
Hmm.
Executive engineer, my lord, various divisions,
Hmm.
that is, my lord, next page, Annexer P1, page 31. Executive engineer PWD Talukbari and Hadu Territorial Road Division given a feasibility report to the chief engineer, stating that the unipoles may be, NOC may be given under certain terms and conditions. These are the terms and conditions mentioned. Similar report, feasibility report given by the Dispur Dimoria Territorial Road Division to the chief engineer, and the Gauhati Central Territorial Division also given the feasibility report to the chief engineer. Accordingly, my lord, chief engineer returned to the special commissioner and special secretary to the government of Assam. That is Annexer P4, dated 4th November 2023. My lord, chief engineer requested the special commissioner.
Anyway, what to do? We'll
Well,
issue notice only. Nothing more. Because you have to pay.
Let them file affidavit.
Because this happened, you issue notice on 15/3/2025.
No.
And he has come before this court today.
No, my lord,
Only,
my lord.
only telling you the demand of bill.
Demand
No.
notice given, two demand notice given, my lord. One is in 2025, that is,
No, why you are not, why you are
my
not
lord,
making payment?
petitioner submitted.
No, what
application.
is your justification not to make payment?
My lord, petitioner given the application before the AMC authority.
My question is, what is your justification not to make payment?
My lord, that
You are,
was not,
this is a
asked-
tax which is payable on account of advertisement. There is no
Asked-
quarrel with
yes,
that.
yes, my lord. But first of all, my lord, the first demand notice given, it is not related to the unipoles belonging to the petitioner, number one. And the second demand notice, my lord, it is too exorbitant. My lord, it is not followed the schedule, third schedule of the GMC rule act, my lord.
Where's
And
the, where's the second one?
second one, my lord. Page 65. Annexer P16.
Hmm.
That is dated 7/3/26. My lord, they are demanded 1,34,66,880. And my lord, the assessment tax 2 lakhs, my lord, per unipoles.
Why
My
do
lord,
you say
this
it is so much high?
My lord, this is the tally with the schedule of third schedule of the GMC Act, my lord.
Let us see. Yes.
My lord, actually, I belongs to category number 1, non-illuminated advertisement on land, building, wall, hoarding, frame, post, structure, etc. The size of the petitioner's unipoles is, my lord, 20 feet by 10 feet.
So
And
20 means
according to-
200 feet,
My lord,
200 square feet.
200 square feet.
So per 100, first AI is for space up to 10. It
Up
is
to 10
it's
square
18
feet,
rupees.
25 square feet per.
18. And then for space from 10 to 25 is 80.
Maybe additional 20.
So already 30 up till 35 it is 98. Isn't it?
Well,
And remaining is maximum amount of tax. Is it per square feet?
by additional 25 feet, square feet, more or less 30 rupees addition, my lord,
For every additional is 30 rupees.
30 rupees.
So therefore, every additional 25 square feet. So remaining is up till you have after this 35 is there. So remaining is will be 165 square feet. 165 square feet will be divided by 7, 8. 8 into 7. Why it is so much?
Now I'll get the instruction right. In fact, my lord, he has no permission also.
And then demolish it.
That's demolition has been done, part of the.
My lord,
demolition.
my unipoles has been demolished, my lord. That's why, without giving any notice.
Not
Or
notice,
so-called, my
illegal things, no notice.
my lord, my
notice.
submission is that, my lord.
Now, did you
this
take
is-
the permission before erect? No.
These are not illegal.
Have you taken any permission?
My lord, that is coming, my lord. Kindly see. That's why, my lord, I am ready. I am.
No, getting that
fighting.
permission from PWD would not.
No, my lord, kindly see that after this letter, my lord, chief engineer requested the joint commissioner as per direction of the deputy commissioner, deputy secretary to the chief engineer, my lord, kindly see annexer.
Okay, we issue notice. Let us see. Both stay. Issue notice making it returnable on, you file your affidavit by 31st.
Lots.
Yeah, but issue notice making it returnable on 31st of July 2026. Mr.
In paragraph 25, my lord, 20,
appears for respondent number 1 and 7. You appear for respondent number
I pay for
6.
2, 3, 4, and 6.
2, 3, 4, and 6. And Mr. B. Gogoi, the learned additional advocate general, appears for respondent number 5. Extra copies of the resolution be furnished by tomorrow. The grievance of the petitioner herein is that the respondent number 3 have issued 2 bills, 2 demand notices upon the petitioner amounting to rupees 15,36,000 and rupees 1,34,66,880 dated 17/3/2025 and 7/3/2026, which are not in conformity with Schedule 3 of the GMC Act. Mr. P.C. Day, the learned counsel submits that the exorbitant amounts have been sought to be charged upon the petitioner, demanded from the petitioner. Providing the learned counsel submitted, drawing the attention of this court to clause 1, the table mentioned in the schedule, and submitted that in respect to serial number 1 of the demand notice dated 7/3/2026, the amount could not have been more than 1,000. However, an amount of rupees 2 lakhs have been charged. In the same way, there is exorbitant charges being made against all the other
up to 6 numbers to prove.
unipoles set up by the petitioner. So, taking into account the above, this matter again, taking into account the said submissions, the respondents are directed to bring on record the respondent number 2, 3, and 6.
2, 3, 4, and 6.
4 and 6.
2, 3, 4, and 6 are directed to bring on record their stand by filing the affidavits on or before 27th of July 2026.
My lord,
List the matter again on 30, list accordingly.
my lord, my humble prayer, and see my prayer of the petition, my lord. That is the main prayer, my lord. My main prayer is that they have pull down and remove the unipoles without giving this as notice or as show cause, my lord.
Now, what will you, this is the thing which has been already happened.
My lord. So, my lord, I have prayed for a direction to the respondent authorities to reinstall.
No.
My lord.
No.
Kindly see, my lord, paragraph
We'll
25.
consider later.
Paragraph 20, kindly see, my lord, paragraph 25 and 27. My lord, these are, my lord, I have stated that on 19/5/26, they have removed.
Absolutely, without permission, why did you?
No, my lord, without permission, that is not correct, my lord. It is implied permission given by the.
Let them find the affidavit.
So, my lord, that is the notice show also show cause notice or they may be directed to file affidavit. Why they on 19/5/2026 had my lord demolished the all the unipoles installed by the
Mr. Bora, there is an
without
appellate
giving any
remedy,
show
na?
cause notice.
There is an appellate remedy, na? He can file an appeal,
There is the provision of appeal in the every order of the commission.
a commissioner. We dismiss
My lord,
and send you to appeal.
my lord,
My affidavit come. Let my affidavit come, my lord.
Will consider. James, the respondent number so and so shall bring on record their stand by filing an affidavit, not only on the question pertaining to the allegation of exorbitant charging by issuance of impugn demand notices, but also on the question as to whether also on the question as regards the legality of the actions of the GMC authorities in pulling down the unipoles so set up by the petitioner without influence of the show performance. Nine, affidavit in opposition filed by respondent number 2.
Nine.
Appearance, all. No. And the parties are duly present. And the affidavit of the respondent number 2 has been filed. This is the matter for admission on urgency, no urgency.
Urgency, no.
Urgency. On 29th of July 2026, liberty given to the petitioner to file reply on or before 27th July.
Okay. Here there was a direction to take steps on respondents for by testimony. However, the affidavit of compliance that could not be filed.
You want more time?
Yes, Your Lordship, so that I can serve a copy on the respondent for
Who is respondent number 4?
the Belguri Satra.
Huh?
Belguri, Sri Belguri Sakha Satra.
Why you are not taking the steps?
We have provided the notice.
What steps you want to take?
The dusting.
The counsel appearing on behalf of the petitioner submits that the petitioner may be granted the liberty to take steps upon the respondent number 4 by way of dusty rooted to the registry of this court. Taking into account above, the instant petition is directed to be listed on 12th of August 2026. In the meantime, the petitioner shall take steps by way of dusty rooted to the registry of this court and file an affidavit of service on or before the next day.
Your Lordship, there is an interim.
What interim one? You don't take steps and no interim. Interim order. Yes,
Yeah, my Patna land has been forcefully taken away by the cancer.
the newly implemented respondent number 6, no notice has been issued.
They last time they were. Or the same day.
GMDA, where is Mr. Bora? Okay. This court duly takes note of that by the order dated 11/5/2026, the learned coordinate bench of this court had implemented the respondent number 6. However, no notice have been issued till date. Mr. Espora, who appears on behalf of the, who also, Mr. Espora, have you seen Mr. Espora appears for GMC. Mr. Espora, the learned counsel who appears on behalf of the respondent number 4, that is the GMC, submits that he also appears on behalf of the respondent number 6. Taking into account the above, issue notice upon the respondent number 6, returnable on 10th of August 2026. Extra copy of the petition be served upon Mr. Esbora who accepts notice on behalf of the respondent number 6. The respondent number 6 as well as the other respondents who have not filed their affidavit in opposition are granted liberty to bring on record their stand by filing their affidavits on or before the 5th of August 2000.
Sagalo Bisag and James A. Final. Sagalo Bisag and James A. Final.
That is why I say those who have not.
This matter pertains to your lordship freezing of my bank account, your lordship. Your lordship, as per the office note dated 22/6/2026, your lordship.
What is the amount?
Your lordship, disputed amount is 27,500, your lordship.
Okay, we pass an order giving that lien.
Yes, your lordship.
Dispose of the lien side.
Not the problem.
What is this?
My sincere apology due to non-prosecution, my lord. My writ petition was dismissed, my lord. My sincere apology, I was not in the court on that day, my lord. My respectful prayer is to restore this petition.
What is your ground?
Down, my lord, within 30 days, I filed murder immediately when I comes to know. My affidavit, my lord will find it page 13, my lord. After 30 days, my lord. I have comes to know that it has been my sincere.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so who appears on Egita Nampira delivered. Is an application filed seeking a direction for recall of the order dated 19/1/2026, whereby the accompanying writ petition being WPC number 2739/2023 have been dismissed for non-prosecution. This court have duly perused the grounds which have been, the reasons which have been mentioned in the instant writ petition. And this court is satisfied that the petitioners have been able to make out a good ground for recall of the order dated 19/1/2026. Accordingly, the order dated 19/1/2026 is recalled and the accompanying writ petition is restored to the file of this court. I stand for this.
I'm deeply obliged.
What is your case? Argue. Argue.
Restoration, ma'am.
No, restoration, I didn't ask you anything. Now argue the main matter.
Not today, my lord, any other.
No, that means I dismiss it. On that day also you were not ready. That day also you are not ready, that means, when the matter was there.
That day, my
That
lord,
is why it got dismissed.
got dismissed, but I was not in the station, my lord. I was busy in my political activities, my lord.
Then
After restoration, my lord, when I was visited, my
argue.
lord,
Let us see. I don't require argument from this. What is the case?
my initial
Reach in the minute should not be issued directing you.
Initial case was basically, my lord.
Correct the land report from here. What is this case?
prayer, my lord, will find
They are
faith.
not in a position to proceed an individual and since the cause of action of so and so. You have been granted allotment.
I've been granted my place.
Huh? What is there?
Prayer is basically
No, no. You see, what is your prayer? And what, see that, what has been ordered. See, number one, Abdul Aziz, he has been granted allotment. Number two is Yasuddin. Yasuddin is here. Yasuddin, Asna. Usman Ali. Has he got it? (32%). They have given the name of so many persons. Have you looked into it? Okay. Yes, madam. This affidavit which has been filed. Yes, you know this. This affidavit which has been filed, and affidavit filed by respondent number 2, it is categorically mentioned out here that these paragraph 6. The deponent states that as per the Khatian register,
Did not match did not match the name of the petitioner.
none of petitioners or the petitioner's names are not recorded as Khatian holders. The Khatian copies as submitted by the petitioners are not matched with the allotment register and details are mentioned above. But as per land records, so the present possession over the land has not been found as per the allotment certificate mentioned above. So you end it with there. Don't you think that something more is required to be stated? Now, have you granted the settlement or not? Because this affidavit was filed in the year 2024. And these allotment certificates were issued when? 82. 82 these or no? When were these allotment certificates issued? Any idea? No date. No. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers 2 and 3. And Ms. So-and-so appears for the respondent number 1. The petitioners herein claim that they are they were in occupation of various plots of land being Rayati Khatian holders oblique Rayati Khatian holders pursuant to the acquisition of land by the state under the Assam Fixation of Land Holdings Act 1956. 520 bighas of land, because 2 katha 9 lectures of land were acquired. It is the case of the petitioners that in terms with section 15 of the Act of 1956, the petitioners ought to have been granted the settlement. 15 and 16 some persons, some of the Rayati Khatian holders were granted the allotment and settlement. However, the petitioners were left out. It is under such circumstances the petitioners have approached this court. This court have also taken note of the affidavit which have been filed by the respondent number 2, wherein details have been mentioned as to whom allotments have been granted. And it is also mentioned that these petitioners are not presently in occupation of their lands. Reference were also made to the Assam, to clause 1.1 of the Assam Land Policy of 2019. The question, however, arises in the present, this court, having noted the affidavit in opposition filed with the respondent number 2, finds it pertinent to observe that there is no mention as to when the allotments were made. And further, what further steps have been taken pursuant thereto? There are the material particulars as regards the allotments so made, the verification which were carried out, are missing, which are material are missing in the affidavit in opposition. Accordingly, list this matter on 19th of August 2026. In the meantime, this court directs the respondent number 2 to file a detailed affidavit providing as to whether each of the petitioners have been granted any allotment, and if so, when, and as to whether the Assam Land Policy of 2019 would be applicable if the allotment was granted prior to the Assam Land Policy of 2019 having come into force. First, next time you come prepared, don't come in this manner.
I'm sincere, my sincere apology, my. Due to pendency of this petition, my lord, the land acquisition authorities have not been releasing the acquisition compensation of subsequent acquisition.
You are the owner of the 7 acres, 2.5 acres.
No, my lord, not I am honor, my lord. Erstwhile honor, but the part of my lord, who are respondent numbers, my lord. In the repetition, my lord, you may kind of see. Not in the repetition, my lord, in my implement application, your lord, you may kind of. Alma Alam and Stephen writing, they were the honor, my lord.
Who?
Alma Alam writing and Stephen writing. My lord, in my implement application, page 26. Yeah, predecessors were the honor. But they have got the acquisition compensation of land acquisition of 1975.
Who?
The recorded Patadas, my lord.
And who are the petitioners?
Petitioner claims to be the recorded riot in respect of land acquired in the year 1975.
They have got the money.
Patadas have got the money.
Petitioner has not.
No. Well, this is the extent of the government in their affidavit.
Lordship cannot see. The acquisition compensation were released in the year 1991. They were given to the Patadas, my lord. Since 1991 till filing of this petition, there was no claim against the acquisition compensation of 1975.
And who are you?
My lord, my lord, I have acquired the land. Your lordship cannot see. Mentioned in the schedule, page 33, my lord, of my implement application. Recently, my lord, GMC has acquired this land, taken possession from me, and compensation is yet to be released in my favor. Page 33, my lord. 2 bigger, 4 kata, 70 lesser.
How have you acquired this land?
From the Patadas,
When?
by virtue of degree, my lord, that I have annexed, annexure number 1, my lord,
But this land has already been acquired.
recently acquired, my lord, for extension of the GMC, by taking over position from me, my lord, annexure 1. This land was taken over from me, my lord. Annexure 1, lordship cannot see page 12, and more particularly page 12B. Page 12B, my lord.
Well,
12B. Circle officer has taken over this land from me, my lord, Karibuddin Borpia.
now this is not a part of that land.
No, my lord. This is,
Then why do you want to be a party of this?
my lord, due to pendency of this petition, my lord, the amount of fertilization of this acquired land has not been released by the litigant.
How is it possible? This is a different acquisition, that is a different acquisition.
But my lord, Dag and Pata has been shown.
So what?
Dag and Pata has been shown, my lord.
Where if it is the government stand out there that they have already paid for those people,
Yes, my
where is
lord.
the question of you asking out here?
But,
It's a different thing, that's a separate course of action. How, why do you need to be a party in this instance?
because my lord, same land has been claimed in this case, which was claimed earlier by filing a civil suit, which got dismissed.
That's a different thing.
And that,
But this is a different acquisition proceedings. How is it relevant out here?
in the repetition, my lord, in the repetition, this land has been included to be land belong to the petitioner under right. That's why they are kept holding. In the repetition, my lord, this land has been included as the right land.
Come this way.
Our submission when land was acquired long back and possession was taken about long back. Here is the, here is the,
Mr. Saikya, who are you?
I am the riot. Because my name.
You
is
were
here,
not paid the compensation.
compensation.
Who were paid the compensation?
Computer riot, that share of the riot, my lord, they issued a no. That are my case number.
Who were paid the compensation?
Compensation, Pottadar has got their share. Pottadar, long back, and they left for heaven also. Now, I was a riot from long back. I have annexed that in my petition.
Then why did you wake up in 2020?
No, but my lord, that while I was submitting petitions, that I was a riot in the Shita name is there. Since not in the Dhammamundi name is not there, the government is of the opinion that your name is not in the Dhammamundi. So the
I am not on that, Mr. Saikya. My question is, why didn't you ask for compensation by filing a reference application for the time when the award was passed?
That's why I'm showing you. My petition 6-1, 6-1, Q1 will be empty forever.
Because both are, in both cases, it is the same land.
So there are two ducts. There are
127.
two ducts. One duct is
At least come to 127. If you see, 127, the land in question is LA case number 29 of 75, which again notified in 1997, acquiring 7 bighas, 2 katha, 5 letters of dark number so and so, and directing respondents to show cause why should not be the proceedings under so and so should not be notified. again in 1997, so far as it relates to 7 bighas so and so shall not be set aside any year. Now this case cannot now be maintained in view of the judgment of the Pune Municipal Corporation. Indore, what is the judgment? Indore Development Authority, the constitutional bench judgment.
Hello.
Your repetition is gone.
Yeah.
This has gone. There's
Lordship,
no
let me-
repetition.
6131.
Now let us see the other case.
6131.
Ah,
Here, my lord,
it is the same land.
same done, but I have.
Now you want their names to be inserted as riots.
Riot in Damabati.
Now the question is,
Name
Mr.
is very,
Counselor,
my lord, name is.
everything understood, but the fact remains. You may be a person interested. There's no quarrel with that
My
proposition.
lord.
My question is, Mr. Saikia, the most pertinent question here is, once the land vests in the state, how can there be a direction for correction of the records now?
No, reports, my lord, in Shikha, there is the name,
Understood.
but in Damabati.
You want, in fact, it is something like a case which happened yesterday.
Now, case,
No,
The
Mr.
case
Saikia,
32
your case is something like yesterday.
No,
I
you
got
got-
one case.
your lordship.
This is what has happened.
Now, lordships from that side is correct, but lordship kindly see the page 33 of the case 621. Page 30, I mean page 32.
Yes.
This letter is issued on 7/6/21 lordship.
Hmm.
But I asking the director to submit the following documents.
Hmm.
When these documents were thought for, then lordship, kindly see the page 35. The entire money was not paid. Entire compensation was not paid. Page 35. Lordship. The Shindi letter so and so received from the circle officer, Gauhati, revenue circle, fixation of land value for acquisition of land for construction of the Gauhati Medical College and Hospital at place Univary under Univary Mudra. The circle officer, Gauhati revenue circle, letter dated 4/6/21 has submitted the present market value of the land, rupees auto, for a purpose and on the basis of 3 consecutive years, registered shall be so and so and so and so. Now the total they have cost amount that they have calculated as rupees, my lord, very good, and the total purpose 73,96,364. So the land there was above total land eleven because of idea. So for the purpose of this matter, this cost has been she directed the medical college to pay the money to the dish office. So this money has not been so far paid to anybody. Lordship. And thereafter we have come to number 4.
Yes, who appears for this? Government? Why haven't you brought the award? Why? What isn't it the award the most pertinent document? Then
It is for that, we have paid leave of this honorable court to produce.
no, if you, the award was here today, the possession was taken, section 16 would have come into place. Matter is over. But because of your inefficiency, this has happened. This way, why haven't you have included the possession? Why the grave leave is been sought for? Of putting the award? You bring on record that award. Where is the award? Award has to be brought. And Mr. Your first repetition has become infructuous. First repetition has become infructuous. Second repetition, only I can do as you have not got the copy of the award. By applying one or two judgments of the Supreme Court, I can give you the liberty to move the section 18 for a reference on the quantum of compensation, on the apportionment, on the aspect pertaining to apportionment. You have no business out here to be a party. Your petition I will take. But because of you, this has happened. Why the award? You have a copy of the award?
No, I don't.
No, not you, you. Then why did you file the affidavit? You are making this statement out here by some Dipankar Nath has made this statement out here on the basis of that, and he has drafted this, has filed it, and he doesn't have a copy of the affidavit. Not, it is absolutely uncalled for. It appears that the government advocates are not aware of the fundamental principles of land acquisition. Isn't it, Mr. Alam? I think you need to give some lectures. If that was the matter could have been finished. That is the only way out, how it is. Take only hope. Heard Mr. N. Alam, the learned counsel, appearing on behalf of the petitioner. Applicant. With an application filed seeking leave of this court to be impleaded, arrays as a respondent to the instant proceeding, to the accompanying writ petition. The reason as to why the applicant wants to be a party arrayed as a respondent to the accompanying writ petition is on account of the pendency of the accompanying writ petition, the applicant have not received certain compensation. This court duly takes note of the writ proceedings, the contents of the writ proceedings, wherein it is the specific case of the petitioners. They are the petitioners. Where the Khatian Das, in respect to 7 bighas, 2 kathas, 5 lechas of land of Dag number 326 old oblique 1117 new of KP Patta number 10 of village Ulubari, Moza Ulubari in the district of Kamrup Metro, Assam. The said land has no relevance with the land in which the petitioners, the applicants, is seeking for compensation. Under such circumstances, it is therefore the opinion of this court that the applicant is neither a necessary or proper party to the accompanying writ petition for which the application stands dismissed. Reject. Now, you can main point. Mr. R.C. Saika submits that in view of submits that the writ petition being the application number 127/2020 has become infructuous in view of the filing of the second writ petition, being WPC number 6131/2024. The learned counsel further submits that in view of the law laid down by the Constitution Bench judgment of the Supreme Court in the case of Indore Development Authority versus so-and-so, reported in so-and-so, the relief which have been sought for in the instant writ petition cannot be granted to the petitioner. Considering the above, the learned counsel therefore submits that the instant writ petition be closed without prejudice to the rights of the petitioner in WPC number 6131/2024. Accordingly, WPC number 127/2020 stands closed on withdrawal without prejudice to the rights of the petitioner in WPC number 6131/2024. On main ground. Heard Mr. R.C. Saikia, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioner. Mr. S. Roy appears on behalf of the, no, help will come later on. So-and-so appears on behalf of the respondent number 1. Ms. S. Sharma appears on behalf of the respondent number 2. 2 and 8 and 9. 8 and 9.
Put 3 now.
3.
3
No, you are appearing for 2, 5, 8 and 9. And she will appear for 1, 6, 1 and 6.
and put 3 and 7.
3 and 7. And PWD also you are appearing. Mr. So-and-so appears for the PWD. To Baigita Borai. Huh? It is a specific case of the petitioner herein that one Muhammad Badiul Alam was in uninterrupted khas and peaceful possession of a land at measuring 10 bighas 2 kata 13 lechas, out of which 7 bighas 2 kata 5 lechas is covered by dag number 326 of KP Patta number 10, situated at Revenue Village, Ulubari, within the Gauhati Revenue Circle. Pursuant to an acquisition proceedings which was initiated and registered as LA case number 29/75. The land in dag number 326 of Patta number 10, wherein the petitioner claims to be the righty holder, was acquired. The learned senior counsel appearing on behalf of the petitioner further submitted that this aspect is further admitted by the communication issued by the circle officer Gauhati Revenue Circle, dated 21/1/2023, wherein it was categorically mentioned that the petitioner, namely Muhammad Saidur Rahman, was recorded as a riot at serial number 369 in the draft Rayati Khotian in respect to the land covered by dag number 326, which had measured 7 bigha 2 kata 5 lechas. The learned senior counsel submits that only upon a filing of the affidavit by the respondent authority, respondent number 3, it has come to learn that the compensation in respect to the land at measuring 7 biga 2 gatha 5 lectures of dark number 326 of Patra number 10 was paid solely, was paid to some persons, the landholders, to the land, to the landholder. To the patadars, but the petitioners who were persons interested as they had rights over the land, including the rights to claim ownership of the land, were not paid any compensation. This court also takes note of that pursuant to the award passed in title in LA case number 29/75, the possession was taken over on possession of the land in question was taken over on 11/5/1988, and by virtue of section 16 of the Land Acquisition Act 1894, the land therefore stood vested in the government.
Yes.
The question therefore arises in the instant proceeding as to whether the petitioners would be entitled to any compensation in respect to the said acquisition. It is very pertinent to take note of that this aspect cannot be decided by this court, which has to be decided by the reference court in terms with section 18 of the Land Acquisition Act 1894.
Correct.
Be it as it may, this court duly takes note of that in the affidavit in opposition so filed by the respondent number 3, without any rhyme or reason, the respondent authority, the respondent number 3 sought for claimed the leave not to include the award, not to make the award passed in LA case number so and so, case number 29/75, as a part of the affidavit in opposition. Had this award been brought on record, the petitioner would have due knowledge about the said aspect and accordingly would have preferred that application. But on account of not bringing on record the said award, the petitioner is not in a position to do so. Accordingly, this court fixes this matter again on 17th of July 2026. The respondent number 3 is directed to bring on by file an additional affidavit bringing on record the award passed in LA case number so and so 29/75. Listed.
Matter is part.
Why?
Because matter is hard by watching. Can be a part.
Okay. It is this one. Indo Development Authority versus Manohar Lal, 2026 SCC 304. I got this. Okay, part.
Plus,
Mr. Nath, you kindly bring that. Because if it was there, I could have finished up today matter. He is asking for that has to be decided by the reference court. I can't decide. And Mr. Alam has unnecessarily come here. What is this? What is this?
Let's challenge an order issued by the Assam State Commission.
Why? Why?
They have issued the same without having any jurisdiction as well as
Issued the-
violation-
where is
in
the
violation
order?
of in violation of section 81J.
Whether you were heard,
Yes, yes.
then what is the information to be given?
Information.
Considering the submission as above, the commission finds the claiming exception from disclosure 18(1)(d) in respect to point number 3 and 6 respectively needs a review and detailed justification needs to be provided by the applicant in case of exemption is there. This is because the information is not automatically covered by. In view of the so and so, as the information sought in point nine appears to be voluminous, SPIO would whose office is held of so and so, the information furnished already and the records pertaining to in respect to point number 3 and 6, the public authority shall review the nature of the information sought for and determine whether the exemption from disclosing this can be justified. If it is determined that the so and so is demand, the justification shall be explained in writing. You are challenging this order.
Yes.
19/5/2018. What is the challenge?
RTA application is at page 12.
What I mean? You have been asked to look into it.
Yes.
The court has that the state commission have not directed divulging 3 and 6.
Yes.
Say that if you are claiming it, you have to give justification
Yes.
also, and
I-
thereupon that will be considered. Kindly read this order.
Yes, I had given my justification in my written statement also.
Who are you?
I'm the bank authority.
So that is you are the bank.
Yes. So,
Understood. But then
information-
also this is being now kindly see the order at page 23.
Page 23, yes.
In respect to point number 3 and 6,
Yes,
the public authority, who is the public authority is you,
yes,
shall review the nature of the information
yes.
sought and determine whether exemption from disclosing this can be justifiably claimed.
Yes.
For you to decide that. If it is determined that sufficient justification exists for exempting the same,
Yes,
the justification shall be explained in writing to the appellant,
yes.
to him. Otherwise, the information sought for has to be provided. What is wrong with this order?
Yes.
Have you given the justification?
Point 1 is also there.
Point 1 is okay. Point 1 appears to be voluminous. The SPIO, whose office is the holder of the information, shall allow appellant to inspect the report. So,
No. The appellant kindly peruse the page 12. The information which was sought for.
yes.
Page
How many farmers were given?
How many
loan under
farmers were
KCC
given
from IMA?
KCC
Kindly
loan under
furnish
so and
the
so?
Names of farmers, complete address,
Name of the
address.
farmers, complete address, amount of loan along with photocopy of Jawabandi land holding certificate, land revenue payment receipt. And
So
the-
you say that this is voluminous.
no, in my first reply, I refused to give, saying that it is not related to any public activity for large public interest. And I have said that it is covered by section 8(1) of J. And in my thereafter
Absolutely no. This is-
they preferred an appeal.
No.
in the-
Your 8(1)(a) would not come for this one. Anyway, number 1, numbers 3 and 6. At that period, how many farmers have repaid their loan and availed the additional loan amount? Provide information regarding this.
Yes.
Then,
So
in
yes,
fact, the state commission was right. Is wrong in my sense. They
in-
should have directed this diverging of this amount. This is as per the constitution bench judgment, isn't it?
in
Yes. I think you don't give a thing.
in my reply, I have
After repaying the annual loan, how many days of so and so will the iman? Now, what have you done pursuant to this order? You got to stay here.
yes.
Oh my goodness, you are very lucky now. We vacated
Lordship,
that.
kindly peruse page 18.
No.
Some information has been given to them.
Understood. My question is not that. You see here, so and so, you have given this 1, 2, 3. You are claiming 3, 8(1)(d) and 8(1)(c) and number 6, 8(1)(d). Now 8(1)(d) and 8(1)(e), you are to decide that
Yes.
and otherwise give him a justification. Have you given that?
No.
You should have, why should there be a stay?
And in fact, they are claiming some third party information.
So what?
But those are
Third party information, you may very well say that I have to inform him. Should I teach you what is to be done?
no.
Then
But as
we
per,
dismiss
as
your
per,
petition
as
right
per
away.
section 8
Hard,
1J.
no, hard, Mr. D. Chaudhary, the
just
learned
kindly-
counsel, if no, appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the
Respondent number 1 and 2.
respondent number
1 and
1 and 2. You are appearing for respondent number 3. Leho. The present petition has been filed challenging the order dated 19/5/2025, 2018, passed by the Assam by the respondent number 1, whereby the petitioner have been directed to provide, have been directed. I think I should not give that also. I should direct you to provide.
No, Lordship.
No, I'll direct.
Lordship,
Yeah, I will modify this direction and direct that you
Lordship,
should
as
be
per
given.
section 8(1)J.
Forget about 8(1)A. I
In
have
relation of
no,
public
forget
activity or interest.
no. Personally, you have to take it up. Have you endeavored that? Can you, being the authority, say that I am not going to provide because somebody will claim privacy?
Being a bank authority, they have given me Jamabandi and everything and all the land documents and everything.
Jamabandi is there.
Private respondent has not shown any public interest. For what reason he wants it?
Is there is there a mention that one has to show public interest?
Yes.
Where?
As per 1J,
What does it say?
information which relates to public personal information,
Huh.
the disclosure of which has no relation to public activity or interest, or which would cause unwarranted invasion of privacy of the individual unless the central public information officer or the state public information officer or the appellate authority, as the case may be, is satisfied that large public interest justifies the disclosure of such information. So there is, while passing the order, the satisfaction has also not been recorded that why this is necessary.
Wait, I think I'll modify this and direct you to provide that information. This is a judgment point.
Lordship, information, the information
No,
he
no,
has
no.
got
In
for
fact, the state commission,
complete residential
state
address,
commission was wrong, Mr. Chaudhary. They should have directed you to provide the information. I'll
complete
give you the
residential official
No,
address of
that-
the branch manager and everything.
Yeah, the recent constitution bench judgment I know. This is a very serious
So all the
infraction.
personal information has been sought
So
for.
what? Who are you to say? Personal information, what can you do? The moment a personal information is being sought for, what is your thing?
Section 11.
No, you have to inform the particular person concerned that look here, somebody is asking for this information, and when they are asking me that information, do you want to claim privacy? This is not for you to claim privacy. The privacy would be claimed by that person, and you are now acting on behalf of that person. You cannot do that. That is why the state commission said, kindly look, you therefore give a reason and why this period was given so that you can ask him. In fact, this order, in my opinion, as per the recent judgment of the Supreme Court, the Constitution Bench judgment, you are to diverse this. I'm passing that order away. This is a very wrong thing which has happened. Let me do something good to you. You get all the information. Hmm. Yes. Yes, sir. Supreme Court of India versus Subhash Chandra Gauhati. There you see what is state. Really, 2025. I'm directing you in public interest to provide all information. In view of this judgment, now this constitution based judgment that your scope is very limited now. You too don't have. That person may say, you, what is the interest, are they asking? They are asking that how many people you have granted loan. Obviously, that is a matter of records.
I have given them.
You have given, so
Number I
that,
have given.
given.
The name I
Now, if he wants for the Jamabandi and all, what is the requirement for you? You have to tell those persons that look here, they are asking for your, should I disclose or not? They may claim privacy. The moment they claim privacy, then you have to bring it to them. And then you have to decide, he will submit, that person will submit, and for you to decide to give the information on. That is the role of our PIO. See this? It's a bit longish judgment, 193 paragraphs, but this is what. Challenging the order dated 18/5/2008, 19/5/2018, passed by the respondent number 2. The brief facts which led to the filing of the present petition are that the respondent number 3 on 30/10/2017 prepared an application under the Right to Information Act 2005 before the Public Information Officer, Nalbari, regional office of the petitioner. The said information sought for being relevant, the translated version as provided in Annex A to the writ petition are mentioned hereunder, are reproduced hereunder. The issue involved in the instant proceedings, as would be seen from the impugned order, is in respect to the information sought for at serial number 1 and serial number 3 and 6, which have been reproduced hereunder, herein above. Next. Pursuant to the information sought for, the regional manager and public information officer informed the respondent number 3 that the information which were sought for were exempted under section 8(1)(d) E J of the Right to Information Act 2005. In addition to that, it is also mentioned that the petitioner bank is under compulsion to maintain secrecy about the affairs of its customers, and as per section 13(1) of the Banking Companies Act 1970. An appeal thereagainst was filed by the respondent number 3 before the Chief Information Officer. In pursuance thereto, on 4/1/2018, the petitioner, the appellate authority of the petitioner, provided informations as regards the query number 1, 2, 4, 5, and 7. However, declined to provide information for question number 3 and 6. Being agreed, the respondent number 3 approached the Assam State Information Commission. In pursuance thereto, the order was passed on 19/8/2018, whereby the following directions were issued. The directions so issued is reproduced hereunder, a bold way, page 22. From the information directions so issued, from the above quoted directions so issued, it is mentioned that as regards the point number 1, the same being voluminous, the petitioner should be granted inspection of the records relating to it by fixing and communicating to the respondent number 3 should be granted inspection to the records relating to it by fixing and communicating to the respondent number 3 date and time for inspection during office hours. The second aspect, which is of more importance, is that the petitioner was directed to review as to whether the information in question were such wherein exemption would apply or not. The petitioner was also directed that if there was sufficient justification for exempting the information as sought for at question number 3 and 6, the said justification be informed to the petitioner in writing. Else, the petitioner was directed to provide the information within 15 days. In other words, there was no direction upon the petitioner to provide the information as sought for at point number 3 and 6, but to provide a justification. But if justification can be provided, then there was no necessity. The claim of the petitioner is based upon the fiduciary relationship the petitioner enjoys with its customers. Which though may not come within the ambit of Section 8(1)(d) or 8(1)(j) of the Right to Information Act, but may come within the ambit of Section 8(1)(e) of the Act of so and so. This court finds it relevant to take note of the judgment of the Constitution Bench of the Supreme Court in the case of Central Public Information Officer, Supreme Court of India versus Subhash Chandra Agarwal, reported in 2025 SEC 481. Paragraph number 45 of the said judgment. It mentioned that section 8(1)(e) is a legal acceptance that there are ethical or moral relationships or duties in relationship that create rights and obligations beyond contractual, routine, or even special relationship with standards and typical rights and obligations. Contractual or non-contractual relationship would require that the party should protect and promote the interest of the other and not cause harm or damage. But a fiduciary relationship casts a positive obligation and demands that a fiduciary should protect the beneficiary and not promote personal self-interest. A fiduciary loyalty, duties and obligations are stricter than the morals of marketplace. And it is not honestly alone, but the punctilio of an honor, which is the most sensitive standard of behavior which is applied. The level of judicial scrutiny in cases of fiduciary relationship is intense, as the level of commitment and loyalty expected is higher than non-fiduciary relationship. Fiduciary relationship may arise because of the statute which requires a fiduciary to act selflessly with integrity and fidelity, and the other party, that is the beneficiary, depends upon the wisdom and confidence reposed in the fiduciary. Paragraph number 45 of the said judgment being relevant is reproduced hereunder. This court also takes note of Section 8(1)(j) of the Right to Information Act. And the Supreme Court, in the case of Subhash Chandra Agarwal, Tupra, observed that the state's provision specifically refers to invasion of right to privacy of an individual and excludes from disclosure information that would cause unwarranted invasion of privacy of such individual unless the disclosure would satisfy the larger public interest. This clause also draws a distinction in the treatment of personal information, whereby disclosure of such information is exempted if such information has no relation to public activity or interest. In the backdrop of the above, if this court now again reverts back to the impugned order, and the information which have been sought for it is relevant to take note of that the petitioner bank herein what is KCC?
Yes.
KCC,
Kisan credit.
Kisan Credit
Kisan credit card.
had granted loans, admittedly had granted loans, as would be very much seen from the information so provided on 4/1/2018. The informations which have been sought for at serial number 1 are Jamabandis, land holding certificates, land revenue paying receipts, which are public documents. The information which has been further sought for in the question number in the query number 1 is to furnish the name of the persons whom such loans were granted. The petitioner bank is not a private bank. It's a cooperative bank.
From under Regional Rural Bank Act.
Huh?
Under the RRB Act, it has been formed.
It's a public bank. And these loans are being disbursed through this petitioner's bank. It is in public interest that such information should be provided. And there cannot be a claim for privacy or exemption in providing the information which have been sought for at query number 1. It being voluminous, the respondent number 2 have rightly directed that inspection should be granted. There is no query, therefore there is no question of interference with the same. Now coming to the query at serial number 3 and serial number 6. Serial number 3. It is seen. Serial number 3 and 7. The petitioners have been granted the liberty to provide justification. If such information cannot be divulged, instead of providing those justifications, the petitioner have challenged the said order by filing the present writ petition. Considering the above, this court does not find any infirmity in the order passed by the respondent number 2, dated so and so, for which the writ petition stands dismissed. The interim order stands vacated. Further, on account of the trouble which is the petition respondent number 3 has faced, this court imposes a cost of rupees 2 lakhs. 2 lakhs.
Public bank law.
So what? Public bank on one hand, you don't want to provide information. Public bank.
Those are
And you don't want to pay.
those are the personal information.
These are not personal. Can Jamabandi be a personal information? Tell me. Can an inspection be carried out by
Residential
you?
buildings
No,
will
no.
take place.
Can an inspection be carried out by you in respect to the lands? Whether you have it or not, that's a different thing. Whether did you carry any inspection? Can there be a proper of a public bank? No. Can you tomorrow say out here that we have granted certain people extensions, some waivers? After all, it is public money that you don't want to divulge. And now you say it to be a private, it's a private bank, public bank. So don't impose cost. 3 lakhs is less. No? 3 lakhs has cost. The chairman of the petitioner bank is further directed to deposit the cost of rupees 3 lakhs before the registry of this court within 7th of August 2026. In addition to that, shall also file an affidavit of compliance. The registry of this court, upon receipt of the said cost of rupees 3 lakhs, shall remit the said amount to the Assam State Legal Service Authority, and the state Assam State Legal Service Authority thereupon shall provide, shall remit, shall thereupon use the same for its various activities. Next, this court further directs that in the circumstance where you are head office, this court further directs that in the circumstance the amount is not paid, that cost amount is not paid within the time so permitted, the registry is directed to take steps before the Bakiza officer, Nalbari, so that the amount can be recovered from Bakiza officer, Kamrup Metro. So the amount of cost can be recovered as areas of land revenue from the petitioner bank. With a cost to say. This is the colleagues.
As per the order dated 1/6/2026, the coordinate bench is Honorable Court has directed the authority to file an affidavit, which is a continuation of the order dated 5/12/2025 and 9/2/2020. So these two order, this Honorable Court is directed to the Union of India to file it for order dated 5/12/2020. Case of it is a part of the land. The year 1998 from one Nabokant of Lokikan Pata. And he has executed the sale deed in the year 2027. 207.
Yes. Mr. Gupta, you wanted to file an affidavit. Why haven't you filed the affidavit?
There was an order passed by this court Lord, constituting a committee Lord, to verify the status of the land. Now, during the course of the Lord, committee, with certain information were asked from the department. Lord, then we have informed to the BTC authorities. Now that page. So this landing. But there admittedly there was no acquisition process carried out. We just,
My question is, are you in occupation of that?
not now, we are not in Mulla. In 2021, we have vacated. 21-12-21, we have vacated. We were in occupation since 2008.
Now, what has happened? You want what do you want here now?
Yeah, for the compensation, they have acquired a land from 2008 to 2021.
So you want the requisition expense, not acquisition. That is what you are asking. Now, you have the land with you? You got the land?
Now, after 2021.
You have got the land in 2022. So therefore, we need to pay the compensation.
We will pay the compensation, not, but it has to be assessed by the BTC authority.
It's going to the person of this report.
The report.
There's no relevance out there. The land on the records is very clear that the land belongs to the petitioner. Don't come up with all these unnecessary. They were in possession from 2008 till 2021. You are to calculate what is the amount payable to him, and they will make the payment. That's all. Why you are unnecessarily making all these things?
So from the report, they are containing that.
Wherever the report, all these reports are useless. all along there has been a committee being constituted to the effect, and on the basis of that, it has been found that it belongs to the petitioner. The fact that the land was recorded in the name of the petitioner in 2006 also is being admitted here. Whether it was purchased for all the some organization or not, that is immaterial. But the name appears on behalf of Mr. Gopal Brahma. There is no quarrel with that report. Now, whether these people have any claim against the petitioner, it's another aspect of the matter. You are simply to do one thing, make the calculation. Now, kindly see the Assam. Have you ever kindly consider this Assam Land Acquisition and Requisition Act? When they took it up, yes. How are you going to calculate? This is a case for requisition of the amount. We have this book.
Lordship, I don't,
Have you ever seen this book?
Lordship, I have seen.
Compensation, 11. Eleven four, where any land is requisitioned under section 3, there shall be paid subject to the provisions of section 5 below. To every person interested, such compensation as may be agreed upon in writing between the person and the collector, between him and you, or in absence of an agreement, reasonable compensation in respect to the requisition of such land and the damage done during the period of requisition of the such land other than what has been sustained by reasonable wear and tear. Provided that in determining the amount of compensation, whether in the case of an agreement or otherwise, such amount shall not exceed the rent payable under the provisions of the Assam Urban Area Rent Control Act or the Assam Non-Agricultural Area Urban Area Tenancy Act or the Assam Temporarily Settled Districts Tenancy Act, so far as they may be applicable for any statutory enactment or modification thereof. So in terms with 11.4, you are to make the calculation and place it and give it to them. When? 2 weeks. 2 weeks you make this calculation from 2008 to so and so, give it to them, and thereupon they will make arrangements for making payment. We'll have an update on the next day. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so who appears on behalf of the BTC, and Mr. A. Gupta who is the learned CDC. The materials on record clearly indicate that for the period from 2008 to 2021, the petitioner's land was under the occupation of the by 13 commanding officer, Army Camp Simla, Indian Army C/O 9980. The possession of the land have been handed over to the petitioner sometime in the year 2021, and the petitioner is in possession of the said land. The issue involved in the instant with petition pertains to the compensation payable to the petitioner for the period from 2008 to 2021, when the army camp was in possession of the petitioner's land. Though no steps were taken for requisition of the land prior to taking over the land by the army authorities, but it is the opinion of the court that the said compensation has to be worked out in terms with section 11.4 of the Assam Land Requisition and Acquisition Act 1964. Accordingly, this court directs the Revenue Secretary,
Lordship, the Director of the Secretary Land Revenue, Lordship.
Secretary Land Revenue of the BTC to make calculation of the compensation payable to the petitioner in terms with section 11(4) of the Act of 1964, and thereupon submit the said details to the commanding officer, to whom? And place the same before this court on the next date, so that appropriate directions can be passed to the concerned army authority respondents for making payment to the petitioner. List this matter again on 22nd of July 2026. The calculation, the details of the calculation be furnished by way of an affidavit to be filed by the secretary law of the on or before 27/2020.
I filed one additional affidavit, my lord, but it was not checked with the file.
What? Uttam Roy Iron Clouds, what is that? The one, these matters came up before me, nah?
Yes, my lord.
What is this?
As per last order, my lord, the Honorable Court directed to file one additional
We by
affidavit.
the additional director of social welfare cancel the specialized adoption agency run by the so under section 1. Have they filed affidavit?
Yes, my lord. Yes, my lord.
When?
Yesterday, my lord.
It has been brought to the notice of this court that the respondent number, who has filed the affidavit?
I, my lord, petitioner. My lord.
No, who has filed the affidavit? Have they filed affidavit? No.
No, my
What affidavit you filed?
one additional affidavit, my lord, to bring
Submitted that the petitioner had filed an additional affidavit bringing on record the relevant adoption regulation in terms with the order dated 18/5/2026. This court also takes note of that the respondents have not filed any affidavit in the instant proceeding, in spite of the fact that the writ petition has been pending since 2022. Considering the above, list this matter on 7th of August 2026. In the meantime, the registry shall bring on record the additional affidavit filed by the petitioner, and the respondents herein are granted the final opportunity to bring on record their stand by filing the affidavit.
most.
What is this?
Also, in this matter, the petitioner here is agreed by the wrong inclusion of the name of the respondent number 6, whose name has been included as a nominee in his service book. Also, and petitioner here is trying to remove the name of the
In your
respondent.
case, affidavit filed,
Yes, okay.
and you're not filing reply,
We
or you have
filed
filed
a
reply also.
This is private platform.
Who is paying for the private respondent? Why is the private respondent here? You want the name of Manisha Kumari to be inserted
Yes, sir.
with your wife.
Instead of Kritika,
Instead of respondent number 6.
Who is paying for respondent? Okay, it's It is seen that an affidavit in reply has been filed by the petitioner. On today. The records reflect that an affidavit in opposition reply has been filed by the petitioner today against the affidavit in opposition filed by the respondent numbers 1 to 5. The respondent number 6 have not filed any affidavit in opposition. And also, there is no representation. Considering the above, list this matter again on 12th of August 2026. And taking into account that there is no further pleadings to be filed, an attempt shall be made to dispose of the petition on the next day. What is the
matter before me? I'll very briefly narrate the facts, mother. Known to the filing of
what is your
the
case?
instant writ petition, mother. Well, the petitioners, mother, before your lordships, both senior citizens, mother, they are the absolute owner of a multi-storied building, mother, situated over a plot of
that one.
yes, 1 bigha 5 lechas, mother.
You got the money.
No, my lord, sir. They used to
That
run
was
a
a long order.
Lordship, before going to the facts, Lordship, we have filed one affidavit, Lordship. His
My lord,
building is not required, Lordship. Now,
I'm not
our
paying for that.
project is already
My case is
complete, Lordship.
totally different, lordship. Can you allow me to?
No. Yes, tell me.
Yes, Lordship. I have filed one affidavit, Lordship. Kindly peruse, Lordship, page
When did
95.
you file?
It was filed on 21 January 2025.
Okay, what do you say?
Lordship, I have stated that I am reading, Lordship. For widening and improvement of so-and-so road landing from so-and-so in the state of Assam on EPC mode lands were required, and land in question of this case also falls under the state project. Now the proposed widening of road has been completed in both sides, and footpaths including the drains of both sides of the road also been completed as per the plan, and people and traffic are running smoothly on the aforesaid road. As such, 7 numbers of pillars of building in question of the petitioner, which are over the government land, now not required to be demolished. And if any removal of the enforcement is required, the concerned authority will take action in accordance with law.
Yes, I'm not on that at all, man. I'm not on, my lord has passed an order dated 27/08/24. My lord, may kindly pay you home.
Yeah.
It is not my case that land has been acquired, man. Now what had happened, my lord? When the substance of acquisition was notified in the year 2022, our names that report has not yet been filed, my lord. Yeah, no, it's good for the
But your case is because of the land falls in the government.
Yes.
Government land.
No, my lord, my case is, my lord, it's an admitted fact that the ROW, the right of way, is at the pillar of the multi-storied building. My lord. That is admitted fact. They have also admitted in their affidavit that the ROW is at the edge of the.
No, now they don't want to take it.
No, they don't want it. They don't know. I'm claiming compensation with all due respect on the basis of a communication, my lord, which is dated 27/10/2020. My lord, may kindly take up page 36.
If you have the affidavit, what is there?
No, page 36, my lord. No, I'm on a violation of Article 14. Others have been paid money because their building is at the ROW. That is
They
an
don't
admitted
want
fact.
that land. They
No,
are,
no.
by any
Yes.
chance, has your pillar been demolished?
No.
They
Yes,
say that they are not going to do it.
Yes.
The government, if they
I-
want to do it, will let the government do it.
I totally understand. My lord, may kindly take up page 36 for a moment.
Not necessarily. I think it is high time we discuss.
Now,
it.
Writ
next,
petition.
the photographs also, Lordship,
Yes,
is completed.
Lordship, see the photographs, then I'll.
Where the photography?
Lordship, my additional affidavit, Lordship, filed on
It's not
21st,
fit for
2025,
business anymore,
Lordship.
my lord.
Not fit for the business, then it
Yes,
is.
yes,
that's why-
different thing.
Page 99 and 100.
In terms of their own guidelines, my lord, I'm entitled for compensation. Lordship would come to page 36 for a moment, my lord.
No, here you cannot claim this. Sorry.
My lord, may I kindly peruse
No,
the-
no, if you have any claim for compensation, go there.
My
This
lord,
is under NHI DCL.
yes.
Go there. No,
no,
sorry.
my lord, may I kindly peruse
No,
page
no,
36. I'm not on.
enough.
I'm,
Heard, Mr.
my lord, once.
Miss-
Kindly-
No,
kindly-
Mr.
kindly-
Sir, this is enough. Mr. Mohan,
Just
no.
1 minute, my lord. Just
Division bench will help you, not here.
My lord, kindly peruse.
No, absolutely no. This is a case where they are not doing it. If you have any claim out there, go under 3G5.
Yes. What they have to say, I'll just read it out one paragraph.
Nothing has been
Inviting a reference on the above mentioned subject, it is to inform that for the structure lying at the edge of the proposed right of way, admittedly, my structure lies at the edge of the proposed right of way, land has not been taken over.
Heard
For-
Mr.
for
P.
subject
Mohanto,
item
the
above,
learned counsel
and valuation
appearing on.
measured.
I'm going to dismiss it in 5 lines, giving you opportunity to go to the division bench. I'm not doing. Heard Mr. P. Mohanto, the learned counsel appearing on behalf of the petitioner. Mr. R.K. Talukdar, who appeared on behalf of the respondent numbers.
4, my lord.
National Highway not there. Respondent number 4. Plans to appeal for 2 and 3. And Mr. S. SS for which one? 5, 6, and 7. And 8 whole Mr. P. Naik is there. 8 points. The petitioner herein has approached this court seeking a direction upon the respondent authorities to prepare valuation estimate for damage to be caused to the petitioner's multi-story building, a part of which is sought to be acquired for the purpose of four-laning of the national highway. The petitioner have also sought for a direction upon the respondent authorities to include the entire multi-storied building in the declaration of the acquisition under Section 3D of the National Highways Act 1956, and thereafter include the said multi-storied building of the petitioner in Section 3G estimate prepared for payment of compensation as per the current rates, that is for the year 2021-22. The petitioner have also sought for payment of compensation in terms with the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. In addition to that, the petitioners are also sought for a declaration that they are entitled for compensation for the multi-storied building, a part of which is sought to be acquired for the purpose of four-laning of the National Highway in 1937. In pursuance to the filing of the various affidavits, in pursuance to passing of various orders, as well as the affidavits which have been filed, an affidavit was filed by the respondent number 4 on 21/1/2025. In the said affidavit, at paragraph number 2, in the said affidavit, it is categorically mentioned at paragraph number 3 that a petitioner is encroaching upon the government land and the total 7 numbers of pillars of the building constructed by the petitioner falls under the government land. Be that as it may, it is the very stand of the petitioner, of the respondent number 4, that for widening and improvement of rehabilitation and upgradation of the Dergaon town section on National Highway number 437 to four-laning from kilometer 426.800 to kilometer 437.800 in the state of Assam on EPC mode, lands were acquired and the land in question of this case also falls under the said project. Now, it is also mentioned that the proposed widening of the road have been completed in both sides and the footpaths, including the drains of both sides of the road, have also been completed as per the plan, and the people and traffic are running smoothly on the aforesaid road. As such, the 7 pillars of the building of the petitioner in question of the building in question of the petitioner, which are over the government lands, are now not required to be demolished. And if any removal of encroachment is required, the concerned authority will take action in accordance with law. Paragraph number 3 and 4 of the said affidavit being relevant, is produced hereinunder. Under such circumstances, this court have also heard the learned counsels appearing on behalf of the counsels, on behalf of the parties, and more particularly Mr. P. Mohanto, the learned counsel appearing on behalf of the parties whose petitioner who submitted that irrespective of their decision on the part of the respondent number 4 not to demolish the 7 pillars of the land or of the building of the petitioner, the petitioner's building have become unworkable on account of the construction of the road. He therefore submits that the petitioner's building ought to have been acquired. Full stop. It is the opinion of this court that these aspects of the matter cannot be decided in a proceedings under Article 226 of the Constitution. If the petitioner is aggrieved on the question of non-inclusion of the petitioner's building as for the purpose of compensation, the petitioner either would have to approach the civil court in that regard, or can also approach under Section 3G5 of the National Highways Act 1956, taking into account the judgment of the Supreme Court in the case of so-and-so versus so-and-so reported in 2022, 15 SCC page 1, wherein the Supreme Court have categorically mandated that the provisions of Section 26 to 30 of the right to fair compensation of the year 2013 have to be applied in terms with Section 3G7 of the National Highways Act 1956 for assessment of the compensation. Accordingly, this court is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed.
I can raise those grounds before the.
Needless to mention that all these grounds which have been urged in the instant proceedings, the petitioner can very well urge before under Section 3G5 before the arbitrator.
222.
What is this?
These are two concession areas in question matters. They are put to sale.
This case, my lord.
Yes. Argue they have not filed affidavit. We won't listen to them. Or we will only give them to argue on law points.
Well, he has a bit limited. We also accede to that matter. Now he wants his, because there's only 1 year left for settlement, one of the settlement. He wants his security money back, which we will want to see. We'll return the money.
Huh?
That money which was taken from them, we are returning the money.
Returned?
No, we'll return.
That prayer has been made before the respondents, my lord, and they have accepted that prayer, my lord.
They
Yes, we accept. We can return it tomorrow. By tomorrow, you can return.
Hey, return it tomorrow. Both petitions same.
Both.
But these are different contracts.
Issue.
Mohan's issue is same.
Issue same, my lord. Only ground of delay was, my lord, defined, my lord, in both the cases.
No, these are different contracts,
Yes,
settlements.
yes. Two different areas.
Two different.
So different areas. So I can't pass one order, na? We'll do two different orders, na?
Issue is same. Yes.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. D. Gogo appears on behalf of the respondent number.
I'm
3, 4, 5, 6.
everyone, my lord.
And no, 1 to 6, not 7. You can't appear
Not 7.
unless you are in hand in glove with him.
No, it's not.
Then
No.
Mr. S. Gottakur appears for the respondent number 7. The petitioner in the instant proceedings have assailed the Communication dated 4/11/2022 issued by the
Principal Chief Conservator Forest and the head of Forest. Response number 3.
issued by the respondent number by respondent number 3. In respect to NKD-B-6 Bandar Khua mining contract area, as well as the letter dated 9/11/2022 issued by the respondent number 6, whereby what has happened in those things?
Provisional letter of intent to revoke.
Huh?
Page 82.
Whereby
Page 80 and 82.
whereby the provisional letter of intent which was issued to the petitioner was revoked. And intimated to the petitioner. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that taking into account that the lease which have been granted to the respondent number 7 is coming to an end by next year.
The respondent petitioner, madam.
It was not awarded to respondent. It was with the respondent, petitioner.
Petitioner.
Okay.
We revoked it.
I know. Now it has been given to whom?
No. He is just the intervener.
Okay. That the period of mining lease which was settled initially is coming to an end by next year.
27.
Next year. The petitioner would not insist upon further on the challenge to this impugned communications if the earnest money, earnest money of rupees 1 lakh.
28 lakhs 90,000. The other,
Earnest money of rupees 28 lakhs 90,000.
my lord, the security deposit may be mentioned. My lord, there are other 10% and 15% also.
Along with the 10% of the initial bid security of rupees 13 lakhs 36,850. Isn't it?
My lord. And 1 month contract money, my lord, that is.
That?
1 month advance contract money, my lord.
As
that is
well as the
15%.
1 month advance contract money of rupees
20 lakh 5,000.
20 lakhs 5,274 is returned to the petitioner.
Along additional amount of rupees, my lord, 11 lakh 14,014 rupees.
Where is that?
That is page 9, my lord, paragraph 10.
Well, if the earnest money, if the following amounts are returned to the petitioner, namely earnest money, dash rupees 28 lakhs 90,000, 10%, number 2, 10% of the initial secured bid security, rupees 13 lakhs 36,850. 15% of the annual contract money, rupees 20 lakhs 5,274. Now, additional amount equal to the contract money of which 11 lakhs 14,041.
01.
041. This is your letter which is being written at page 83. That is totaling to rupees 74 lakhs 46,165 is returned to the petitioner. Mr. D. Gogoi, the learned counsel, appearing on behalf of the respondent numbers 1 to 6, submits that the said amount will be returned by tomorrow. Consequently, list this matter again on 13th of July 2026 to provide an update as to whether the amount have been returned to the petitioner.
Forest.
Same Hitu Kesot.
Figures are different.
এইখনত paid, এইখনত 83 আছে, এইখনত কিমান আছে?
কিমান আছে?
Where is the document, similar document?
My lord, phase two is the, my lord, initial bid, phase 60, my lord, initial two, 8 lakh. So, total, my lord, I have stated in paragraph 28, my lord, phase 22. Total amount is 54 lakh 70,053. Phase 22, paragraph 20.
8?
22.
No, how do you get 54 lakh?
My lord, you may refer, my lord. And earnest money is 27 lakh 75,000.
How do I get it?
My lord, paragraph 3, my lord.
No, you can't help me to this. Let the forest department first pay that, then we'll have another thing. You don't have so much money to pay so much. We'll have this matter on some other day.
Well,
Huh? The counsel appearing on behalf of the petitioner submits that he will file an additional affidavit bringing on record as to how much amount the petitioner is entitled to and in what head by filing an affidavit. Is an interim order?
yes, that has to be.
Okay. The interim order passed earlier shall continue until the next date.
Always.
When do you file? You file after that, it will come.
On 13, we will file, my lord.
List this matter on 13th of July 2026.
My lord, Boda case also will file.
No, other case I've already passed the order. Other case, you will get the money, he's paying tomorrow, na? He said that. Otherwise, it will be a contempt if he don't deposit tomorrow. He has line He has given an undertaking. The respond numbers 1 to 6 have given an undertaking to pay the petitioner the entire amount tomorrow.
Well,
Yes.
Lordship, actually, conducting counsel is on leg at court number 6, Lordship. Kindly pass over for short time being.
You have not filed the affidavit.
Like, my lord, copy has not been served to us, my lord, in date, my lord.
Mr. City appearing on behalf of the respondent submits that till date steps have not been taken by the petition. Consequently, list this matter only after steps are being taken. And proof of this, of steps being taken is placed before the registrar.
Lordship. Actually, we have taken step on 13/5/26, Lordship.
No, the
We were
Python
also-
test number, my lord. The Python.
Huh? You have not received. Okay, steps taken. Then? Why you
I have not received.
You have not received. Mr. Dhar. Yes, what is this?
movies of they got married Miller, and down there they living a husband and wife Miller, they are the criminal case. And police was hearing Miller, so the order court will pass interim order. Now we are living Miller, and
This type of, you are asking for a bail.
bill already Miller there, not to harass us. And
You are asking for a bail under 226. Directed not to cause any harassment or arrest to the petitioner if they are involved in any other criminal case. What is this?
and they have filed a FR has been filed. FR filed.
Mr. A. Rashid, the learned counsel appearing on behalf of the petitioner, submit that nothing further remains in the instant retrieved in as much as the case which have been filed against the petitioner. The final report have already been submitted
30/11/20.
on 13/11/2022.
23.
23.
Yes.
Where is that? 30,
Our
30/11/2023.
Yes.
Holding inter alia. That there is no criminal case made out against the petitioner. Taking into account the above, nothing remains in the instant proceedings for which the requisition stands.
Wait, Your Lordship, also I have received some updated instruction in this matter.
What is this?
The shifting of the bus stand to Muralidhar bus stand in Dibrugarh town. That matter,
54 and 55 is the include orders. Page 54 and 55 are the include order. What they have done, they have
The honor to inform the reviewing. Now what happened? Nothing.
nothing has happened.
Now
Now,
what are you challenging here?
page number 54 and 55, where the DLSC has taken a decision. Here, page 54. There was an earlier order of this court where settlement was arrived at.
Where is this Muralidhar Jalan bus stop?
outside the Dibrugarh town, my lord.
Where?
Jalan on the outside Dibrugarh town that I am aware. This is like ISBT, my lord.
But it's not like ISBT. It is not yet ready.
No, it's already.
No, it is
seated.
ready.
It's already
That day I
seated,
saw
not there.
somewhere. They have inaugurated that bus.
Yes, my lord. From
Very nice.
22nd of June, it was fully operated.
Very nice.
Because
This is
while
the-
filing this petition, it was not ready. Firstly, and secondly, my point is that it is not about, they have stopped all stoppages in Dibrugarh town. At least one or two stoppages, they might give, that is enough.
Why?
But they have to,
You stay in Dibrugarh? You stayed in Dibrugarh?
no,
That is why you were saying. You know where the bus stop is? The road will be smaller than the main road out here, which we get. That's it. Smaller than that. They are not in a position to extend it this way or that way because of too much of construction. Then, Mr. Setia, you are from Dibrugarh? Huh? Isn't it? Then, we will dismiss with cost.
Lordship,
Cost for improvement of acquisition, all acquisition costs of the land after breaking, he will.
Lordship, my only point is that only there are some
No,
spaces.
there cannot be any stoppage of the Dibrugarh town now has shifted to the other side. Beyond you see, the Dibrugarh town was on this side. If you go from Gauhati onwards, it was on the left side. But now the Dibrugarh town has developed on the right hand side of the main highway. Because of the fact that this area has become congested like India. There's nothing else. In the area where the bus is there, that area, the proceeding area, that is impossible. So therefore, this is being removed out there. Good. Now they must have removed. Now the railway station is there on the right hand side. But even the railway station is on the right hand side. Now they must have shifted the bus stop to that side. This Mulidhar Jalan bus stop terminus, I think this will be somewhere nearby
It's the highway
Jalan,
only, my lord.
Jalan Nagar.
No, it's a highway, my lord.
So this is on the other side.
Other side.
Lordship,
Bypass.
as per the last order, Lordship, there was an instructions on whether there can be any other place because it is too far.
It's not possible, lord.
And in 7/8,
Traffic congestion.
and on 7/8/2024, the previous order, your lordship's order was there.
Now you have complied with 73(1).
Yes, everything has been complied, my lord. This is not their challenge also. They only wants to bus stop the, inside the Dibrugarh city, town.
Whereas the bus stops currently operating within the city are in the state highway road without any separate space other than the designated. Now therefore, in order to bus from Federal stand to be shifted to Mulidhar bus stop from Swanshaw. No buses shall be permitted to enter beyond Iman. These restrictions shall not be applicable in case of school buses. A joint team of so and so, dedicated route and designated advisory for the movement of buses and regular will be provided. Now, he challenging 54 and 55. You are hereby asked to give immediate direction to the bus owner so and so except CNG under your association to park the way at so and so instead of previous operated Dibrugarh town. Now, because of this, these were of 2022.
Right.
Thereupon, now this order has been passed on 15/6/2026,
Lordship.
where things have changed.
I'll call.
Things have changed. Have a, give it to me. Now, all buses are to go there.
Go there.
Now, there is no CNG buses to go. So, if you have to challenge it.
Yes, they have to challenge that order, 15/6 order. They are aggrieved.
Now, this Mulidhar Jalan bus stop has come up properly.
Fully functional from 22nd of this month.
That day I saw it somewhere. It has become better. Earlier, it was allowing bus stop at that location will create a feeder to services like so and so. However, reserved land is available in front of Japanese Central Iman, approximately 5 meters away from the above.
And Lordship, may kindly have a look page 3 of my instruction, Mansala. Page 3, this is the order.
This got the Dibrugarh name. Where they have been. Yes. Oh, it is on the highway.
Yes,
So, earlier map, it is on the highway.
yes, madam. I'll use it.
Now, this is the Jagannath temple. Here, your bus stop originally was here, Dibrugarh bypass, Jagannath temple. Oh, it is inside only, towards Dibrugarh. Convoy Road, and this is the PR, and
We
this
have
is
given
the.
that.
Huh?
We have
That's
provided.
it.
We
Ah.
have provided that.
Now it is okay.
Yes.
In fact, it should have been this side only. Too far, it's very nearby. Dibrugarh.
The phrase,
This is Jagannath here, so this will go away. This is you have to go left. Okay, Pulbagan. Only 50 reverse so and so. KC Google. Here near Mankota Road, you see the map. This Mankata Road, then you go towards the left hand side. If you go from this side, then left hand side, this is the bus stop.
Yes, my lord.
This near this HS Road, this is the bus stop. Ah. And this is the Jalannagar State area on the right hand side,
Right.
near the KC Gugoi path. Beyond, I mean, other side of Mankata Road. And on the left hand side, you have the Mankata Tea Garden. This tea garden is the Mankata Tea Garden.
Yes, the tea garden left hand side.
And then you come there. This is Jokai. Anyway, nothing. I mean,
Lordship, in the, that map, Marwari Putti area, Lordship, there are white spaces, right? Earlier,
so, Mr. Counsel, you cannot go there. Why should you be going to that side?
one
Because this
stoppage
is
only.
no, Mr. Counsel, kindly appeal. This road which is there, you see the road, there is this arrow which is going on. This used to be the old road to go to from the to cut across the Dibrugarh. So this road which is there, you have the MJ to BT, then you keep on going straight and on, then this Pulbagan and all this thing. Pulbagan is where? Pulbagan is next to the court, the Dibrugarh port. So here the Dibrugarh port is there. And this is the road, and then you keep on coming out there, then you go this side out, you will get this particular route toward Moran side. So this used to be the highway. Now, however, those people who used to cut short there used to come by the middle, this Dibrugarh bypass. This is not the bypass, there is another. They used to cut short by this way. You see the TR Pukon Road? This is to be the cut short to go inside Dibrugarh. And this road with the convoy road is there. Oh, no case.
Yeah. Okay. On earlier occasion at page 36, there was a settlement. After that, they did not comply with the settlement.
No, we have to look into now.
Today,
They have given you a better place. Go
Yes,
there.
Lordship.
No case. Now
Lordship,
let's challenge the-
Lordship will, I'll just take instruction on the phase development. that
No,
will be
lordship, we
taken
kindly
place.
dispose of this matter. I have provided the present
Because
status.
as per law, I am not harping on it, but they
You challenge this
they
if you have to challenge this someday.
cannot do there is no
Which
jurisdiction.
No. As of now, are you running the buses there?
No, they are not allowing.
Then
We're not allowing.
they cannot. Now, if you don't shift out there, then you should stop. Who are you? Esteemed Bus Owners Association. Who are you? How many bus owners? What is that association?
Yes, Lordship.
Let us see your articles of association.
In fact, lordship, there are so many allegations against the petitioner. In our affidavit, we stated all this. Representation has been filed
Page
against the
number
petitioner
27.
association.
Memorandum Association and page 27, 26. 13. Earlier was
There you see, now things are going.
Yes,
Lordship,
Lordship,
you need to go there. Cannot have this. Times are changing.
look at that cause of action has also changed, I think, because of the.
Yeah, if you have anything out there, you challenge this order. Liberty will be used.
No business, no.
Because
No.
this is a separate cause of action.
Yes, madam.
Now, earlier CNG buses were allowed. Now, you are not allowing anybody except school buses.
Yes, madam.
So, and it is, in fact, inside Dibrugarh now. It is not on the right-hand side of the.
Not of any via way that our business can also be safe. In Lordship, I'll just say.
You are bus owner.
Yes.
Bus owners have no business. Wait, are you allowing, can you conceive of allowing these buses to the fancy bazaar? In fact, not the other one. The other one has also become crowded, not on that. But on this side, inside fancy bazaar, can you permit?
Yes,
This is the state of affairs. In fact, smaller than that road.
Yes.
You are asking out there. And the other road which is there, which is in front of the port and all, this is a different road. Yes, that road is a bit bigger, and not on that. But you cannot have it inside that earlier ASTC bus stop. It is impossible. But if you go the other way, you can. But by that, you are going inside the road.
Yes, but just on a particular time, Lordship, on a particular time, suppose on at night or something like
Right?
that.
What are you going to go inside at night?
Night.
No, no, no,
Who are
for night.
the buses there, night
Hey,
time.
night buses, for
My
a
lord, may not
particular
observe
time,
what is
one
the
more 2 hours.
specifics of the matter.
Anyways, I think we should give him an opportunity for obtaining instructions. After all, it is his client's. Tomorrow, clients will ask him. Anyway,
Then tomorrow.
not tomorrow, after.
After vacation.
Yeah, he has to contact somebody from Google. Let him have a peaceful night. Miss MD Bora, the learned standing counsel of the Transport Department, submits that on 15/6/2026, a fresh order has been passed by the chairman DRSC, come District Commissioner Dibrugarh, whereby all buses, whereby the bus and the traveler stand have been shifted to Murlidhar Jalan bus terminus from 19/6/2026. She further submitted that this Murlidhar Jalan bus terminus is under operation since 22/6/2026. So the said instruction is kept on record and marked with the letter X. Mr. D.P. Bora, the learned counsel, appearing on behalf of the petitioner, submits that he has no instruction in that regard, and he would like to obtain the necessary instructions from his client in this client. Accordingly, lists the matter again on 27/2026. The Ipuduga has shifted from here and passed the order on 15/6/2026, along with a corrigendum dated 16/6/2026, whereby all bus and traveler, whereby the bus and traveler stand have been directed to be shifted to Murlidhar Jalan bus terminus from 22/6/2026.
Lordship, may kindly keep my information part of the record, madam.
I have kept it in there.
Lordship, keep your-
Also, can it be 19 or 21 any day? Any day.
19 we can, if it is a Sunday.
No, no, no.
21 is Tuesday, obviously. No. Tuesday is a small matter, 22.
keep your-
Mr. D. Gogoi, I was thinking that in the other matter also, if you can provide me the same. In the other matter, you can
Perhaps
provide
the
me the
schedule.
details as to what I have mentioned in the first matter. Then, as there is an interim order, I will put the order in this manner that upon payment of this, the interim order stands vacated and for an update on the next. Because then you can proceed with your tender. You are losing on that aspect now because of the stay. You ask the person concerned to give a detail of the second matter. Because that is not clear from his if we can just find out that thing, so I can put it out there and say that you have agreed to make the payment. Upon payment, the interim order stands executed, and immediately you can proceed with your tender process. And then update me please as regards payment made or not on the next week. Then you just inform him. So you can now give it, so you can get it typed out. Yes. What is this?
Petitioner is a government valuer, my lord. Registered valuer, my lord. He was impressed by the respondent bank, my lord, Axis Bank, my lord, as a service provider to function as valuer of the bank. Subsequently, my lord, initially agreement was for 3 years, my lord. Subsequently, it was extended. Thereafter, my lord, by notice dated
211,003, my lord.
Your account have been frozen, locked.
Yes, my lord. This is
Why?
one, my lord, I am coming, my lord. Then, my lord, a termination notice was issued, my lord, saying that your service is not good. You are not a regular, you are irregular, my lord. Then matter ended there, my lord. Thereafter, my lord, petitioner found that the account was freezed, my lord. Not only account was freezed, my lord, a fraud report has also been made, my lord, against the petitioner, my lord, with the Reserve Bank of India, my lord. And because of which, my lord, for last 2 years, my lord, petitioner is not getting any job, my lord.
You issue the stopers.
No, my lord, nothing, my lord. This is our case, my lord. Without giving any opportunity, my lord. They unilaterally made the fraud report, my lord.
Because you are terminating him on the ground of some default. Did you ask him?
Your lordship, there was not default, but there was fraud on multiple accounts.
Understood. Lordship, the fraud question of fact which needs an adjudication. Can you take unilaterally without asking him? My question is that. You may very well say, yes, it may be a gross case of fraud. Yes, you may suspend him. But to terminate him, don't you think that there is a requirement at least to ask him why we should not take action for termination? You have the power, but you can, don't you think then also asking him that we are terminating because of this allegation? If you have no allegation, you are terminating, okay, we don't want to go ahead, it is okay. But this letter otherwise casts the stigma. If you have stopped out here at page 22. It was okay. But 23 makes the difference. Therefore, in the light of these breaches, defaults, and deficiency in service on your part, we therefore issue you this notice expressing our intention to terminate your service engaged by you, so and so. The arrangement should be considered lapsed with effect from so and so. All dues, if any, of the year shall be paid by the bank upon submission of the bill prior. However, please note that nothing stated herein above shall be considered denying us any legal right for so and so. Then his bank account has been frozen. By?
By Axis Bank. By the respondent number 7. I'm representing.
You are Axis Bank.
Yes.
You have frozen his bank account.
Okay.
Does his bank account have anything else apart from that money out of your contract?
Lordship, I'm not aware of that, right? But your lordship, if I may just for a minute.
Please.
Lordship, what has happened that he was a valuer of the properties which is supposed to be mortgaged with the bank.
He was the
valuer of the properties which are supposed to be mortgaged with the bank to issue loans. Now, in respect to 31 loan account, there were multiple frauds wherein in some cases there was no properties as such. In some cases, there was the persons who has taken the loan are not the owners of the property. Those were valued by him. And as per the service agreement, he is entitled to indemnify the bank for any losses. I have already annexed the service provider. Your lordship, and then in respect of these properties, the bank has suffered a loss of 6.69 crores. Those are for public money. And he has also accepted that he used to take money from the intending borrowers, which he is not entitled to do. There is a written means out of
Mr. Counsel, I understand completely. You are right. But all these things are right. You are saying that he has done. But answer me to good. Whether it is permissible without issuing a notice. Secondly, how do you get the power to close his bank or freeze his bank account when this power is reserved under the acts? Do you have the power under the banking laws that you can freeze?
Lordship, I'll not say that I have the power, but
if you don't have the power, how are you doing it?
Lordship,
My question is this, you see, Just for example, let us, when you are just submitting it, just recollect it to me. If you are a bank, if you have granted a loan to somebody, normally what a mortgage is there, you cannot go and just get hold of somebody and get the money. Although you may have the power in the agreement, you have to discharge this by way of a suit, claim the money. Therefore, you have that. Then thereafter, there was this DRT for expeditious disposal. You have the DRT. Now, the DRT was also not functioning, giving so relief. So you have that securitization act. Now, this securitization act, if you see section 13(1), gives a very nice example that without the intervention of the court, you can.
Yes.
Okay. Now, power is being granted by an act, by a statute. Where is the power for you to freeze his bank? Merely because he had an account in your bank, can you freeze it? Without an account. Yes, tomorrow Reserve Bank says they may have some direction, they can very well say so. But then also, when Reserve Bank takes a decision also, they cannot take a unilateral decision without hearing him. How are you doing it?
But here the things in most of the cases, the properties are itself non.
Mr. Counsel, I understand how the valuers do, I understand everything. But can this be done in exercise of, can this be a lawful exercise of power by you? My question is that. Everything else is okay. You may very well tomorrow say that, okay, we are issuing you a surplus notice. We shall not henceforth do anything with you for the time being, nothing till you give us a reply to that. All these things you can very well do it. But my question is, without doing it, without giving him, isn't it his violation of his Article 21 rights? I think one. Speaking of the bank account, how is it possible? Unless you get an order from the police to the effect under 102 of now, I don't know, it's 102. For attachment of his property of his bank account. You have to get those. Have you filed a FIR against him?
Yes, sir.
Now, in pursuance to that, if the police does it, it is okay. You may very well fix, but you have not taken that. You cannot on your own have the power to do that. Unless you exist being thanks that we am the police, I am also the court, everything.
Yeah, absolutely right. Your Lordship, can I have some time to go through this immediately after the vacation? If your Lordship do permit.
Okay, we'll have it after vacation, but think about it. Otherwise, this is the case for setting aside immediately. Because this is what you have done is wrong. He may be very well entitled for compensation. Anyways, Mr. So-and-so who appears on behalf of the Axis Bank. Who appears on behalf of the Axis Bank Limited, admits that some time may be granted to him to answer to the following queries. Number one, whether it is permissible on the part of the respondent Axis Bank to terminate the contract with a stigma attached thereto upon the petitioner without giving the petitioner an opportunity to show cause. Number two, whether the Axis Bank, whether the account of the petitioner which is maintained in the petitioner's, maintained in the Axis Bank could have been frozen by the Axis Bank unilaterally without the intervention of the court or authorities who is empowered to do so. This is the matter when
As per
we'll have it here 15th of July.
of the file.
In this case, Lordship, the petitioner's land has been utilized and taken without any process of law loss. without, my lord, any compensation, without execution losses. The petitioner submitted an application representation to the, my lord, joint director, health services losses to pay compensation for utilizing our land. Now, affidavit has been filed.
Read your prayer, page 10,
My lord, in the writ petition.
in your writ petition. Read the prayer.
Under the present circumstances,
Loud, loud.
under the present circumstances, it is there to pay their due lordship if you wish to admit inspection for the request issued for the from the respondents to show cause as to why writ of mandamus was
Oblique,
sorry, lord. Sorry, lordship.
oblique,
Some mistake is there.
read the portion.
Lord. Sir, say it, Lord. Or any other deed of like nature, orders of taxation shall not be issued, directing the respondents to pay adequate
Who is in
compensation.
possession of the land, madam? Are you in possession of the land?
I affidavit lodged yesterday only.
Ah.
I think it's not in the report.
Affidavit filed by, what does the circle officer say? So and so, the polling states that the mutation of inheritance of so and so, so and so, so and so is going on under the course of the land.
Paragraph 4 was
Explained in the mutation of inheritance of. This affidavit is also not clear.
that number is minor there. This is the.
Land value of the land is 50
Now,
lakhs.
my lord, joint director has filed, my lord, has admitted everything loss. My lord, now not disputed the abutments loss.
Right.
Only as regards paragraph 3 lordship.
Paragraph 5,
Uh,
lordship, there is no any official document regarding the land handed over to the authority.
Nothing was there.
No, my question is whether the land belongs to the petitioner, one. And secondly, are you in possession of the land? These are the two things. If you are in possession of the land and it is the land of the petitioner, you have to acquire it or hand it over back to him. Simple.
Loss.
We get that instruction on the next page. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss So-and-so appears on behalf of the respondent numbers 1, 2, and 3, 1, 2, 3, and 4. Mr. Ngusami appears on behalf of the respondent number 5 and 6. The petitioners herein claim that they are the owners of a plot of land at measuring
1 kata 7 less.
1 kata 7 lectures covered by dark number 467, included in KP Pata number 34, situated at Dhigzari under Moza Posim Banbag, under Ghagrapur Revenue Circle in the district of Nalbari. It is the specific case of the petitioner that upon the land of the petitioner, the respondent numbers 1 to 4 are running the Dhigzari, Dihjari, health sub-center without any authority of law running the health center without the permission of the petitioner or without without acquiring or requisitioning the land from the petitioner. It is under such circumstances the petitioner has approached this court. The records further reveal that an affidavit has been filed by the circle officer Ghagrapur, wherein it is mentioned that the said land have been mutated yours is 464
Yes. Yes, Lord. I went for 6.
and your prayer is 467.
464.
It is the case of the circle officer. Now, this court have also taken note of the affidavit in opposition. Wherein it is categorically mentioned that the land of the petitioner is in dark number 464 of patta number 34 and not the land which is claimed in the writ petition, which is dark number 467. The said aspect is also apparent from the Jamabandi copy,
That's 16.
wherein it is categorically mentioned as dark number 464 of dark of patta number 34. Mr. Counsel, I am dismissing your petition.
Correct.
Taking into
File
account the above, the entire edifice on the basis of which the petitioner has filed the instant writ petition appears to be faulty, for which the writ petition stands dismissed.
Lordship may be allowed to file it
What?
for amendment.
No.
Then, Lordship,
Yours is 464.
file 460.
You are saying that they are in 467. Then, and this is another thing, why I'm saying. Page 16, you see 464,
464, mine only.
and then page 14, you say 468.
My lord,
You don't know where your land is?
my lord, this is my document, Lordship.
Liberty, however, is granted to the petitioner in the circumstance the petitioner has information, have material, proper materials to show that the land of the petitioner, which is in dark number 464, is being encroached by any authorities.
My lord, by amendment.
With cost do you want?
Lordship, and typographical loss.
Cost upon 10,000 upon you?
Lordship, my lord, this is for compensation. All right.
I'm giving you the liberty if you find any.
Yes.
Yes, Mr. Kadir. Very old matter. Huh? 25 is new, very new to you. That is the spirit of the forest department, not the state.
For Assam State Acquisition of land belonging to the Gujarat and State institutions of public nature act and are entitled for settlement. For settlement.
That has not been considered.
No.
Mr. There's an interim order also.
Yes, madam. Not to discuss possession, not to.
The cook. This court have issued notice on 28/5/2025. And in the said and while issuing notice, this court further directed that the petitioner's possession over the land in question should not be disturbed. In spite of that, for the last 1 year, the respondents have not filed the affidavit. You want to file or don't want to file? Mr. S.S. Roy, the learned counsel appearing on behalf of the respondent, submits that he would like to, that the respondents would like to bring on record their stand. Taking into account that above, the final opportunity is being granted to file the affidavit in opposition on or before 11th of September 2026. List this matter on 18th of September 2026. Taking into account that the respondents have not cared to file the affidavit for almost a year, for more than a year, it is the opinion of this court that the interim order so passed earlier should be continued with the disposal of the requisition. Accordingly, the interim order which was passed on so and so shall continue till the disposal of the requisition. What is this?
Lordship, in this case, your lordship, petitioners has challenged certain actions by which your lordship allotment of land, so far as their concern has been cancelled without hearing them.
Speaking orders passed.
Lordship will kindly, that is your lordship. Your lordship will kindly come to 107, the speaking of
107.
107. Page WPC 3874.
Any speaking order, 107, 108. Okay, show me, yes, speaking order, what is that?
Whereas Sri so and so has been issued allotment certificate in his her name or her predecessor, and the allotment has been rejected due to non-conformity of the stipulated conditions.
And
then your lordship will kindly, this is the speaking order, and then they say, your lordship, these are the conditions, your lordship. When these allotments were cancelled, we have not been happy. That's the basic piece, your lordship. And your lordship will find in.
so these speaking orders of 21/4/2025 was passed without hearing you.
That is, this is your lordship, that is page 123, your lordship may kindly come. Hereby cancelled, your lordship, by circle officer, that is. And
But
then,
is a notice.
lordship, that is notice,
You
but
are
your
hereby
lordship,
directed to so forth and file representation
Lordship.
along with supporting documents within 15 days from the date of issue of the notice as to why you should not be evicted from the land.
that is your lordship. First of all, your lordship, we are allottees. We have allotment certificates, your
Now,
lordship.
this is subsequent.
Lordship,
This is a subsequent
Lordship.
to your notice.
lordship.
Now, you were initially allottees.
Allottees, your lordship.
Where's your allotment?
Your lordship will get it at page. It starts from page 21.
Notice of the allotment letter and certificate of financial aid.
Lordship.
So this land has been allotted to you.
Allotted to us.
Then
Your lordship, we have been occupying that, your lordship, for residential purpose, your lordship. And then all of a sudden they have decided to, your lordship, set up, give that portion of land, including others, your lordship, for a particular project, your lordship, to be undertaken, power project, thermal power or something like that. And on that, your lordship, apprehending that we may be evicted, we came before this honorable court, and honorable court directed them to pass speaking order, your lordship. And when the speaking order was passed, we came to know that they have already cancelled our allotment without hearing us. Now they have filed their affidavit in this particular
no,
case.
let us, so therefore that is the biggest problem. So the question is first you have to be given an opportunity
Lordship,
to
that is what your
submit.
lordship.
The order is wrong, the coordinate bench has made that mistake. The law regarding eviction is so and so Salahuddin in view of the procedure laid down in others and so and etc. That if any eviction is contemplated by the in respect to the plot of land claimed to be in occupation of the petition, then such action must be in strict adherence to the procedure of so and the rules to endearing and the direction made here also includes a prior notice to each of the petitioners we have. Now this is, you came out here on the basis thinking that you will be evicted. Hearing that something to this.
Lordship.
Now this order was passed on 5/5/2025.
Lordship.
Now prior to that, 21/4/2025
2025 order has been passed, your lordship, we have never been heard. And your lordship, that allotment has been cancelled, that we have come to know from these orders, your lordship.
How did you get hold of this order?
Subsequently, your lordship, I came to know, your lordship, this.
How?
And then your lordship will also.
How did you get hold of this order, speaking order?
Picking order is that your lordship will find it at same order.
Now, page 107
Lordship.
onwards, how
Lordship.
did you come to loan?
That your lordship have made.
Then in pursuance to this notice, which have been issued on 12/6/2025, did you
Lord.
submit your reply?
No, your lordship, we submit our reply. When these notices were issued, your lordship, we came before this honorable court.
You came before this court.
Lordship.
Now, in the earlier proceedings,
Lordship.
on 5/5/2025, when the order was passed,
Lordship.
then in that proceedings, was it informed that your settlement would be,
No,
allotment
Your
have been cancelled?
Not, that has not been informed.
No affidavit to that effect?
No, no. And in the present case also, they have filed their affidavit. And in the affidavit, they say they have not denied that, your lordship, that we have not been given notice. They only say, your lordship, however, it is pertinent to mention that a land parcel of 200 bighas covered by so-and-so has been earmarked at village Chirakhoa Part 2 under Athani Revenue Circle for reallotment of the petitioners. So, your lordship, they have said that 200 bighas they have been kept aside in a particular area for resettlement. Your lordship, so far as these allottees are concerned. That is
So they will be giving you,
lordship.
where?
That is in place, your lordship, Chirakhoa Part 2. That is the village, your lordship, but that is not, we have brought and filed an additional affidavit, your lordship. By filing that additional affidavit, we have tried to brought to this honorable court's notice the area where they have decided to rehabilitate us, your lordship. This is not a habitable area, your lordship. This is by the side of the river, your lordship. And whether they will give us patta, etc., that is not there anything, your lordship. Ultimately, we being allottees, your lordship, we are entitled to
Now,
first of all.
if they say that, you can take it up, ask them to give them pattas.
But your lordship, no, your lordship will kindly see. There is an additional affidavit. Page 185 to 88. Your lordship. These are the areas, your lordship, where how can one reside here, your lordship? And ultimately, your lordship,
Where?
page 185, your lordship. These are the areas where they want to resettle us, your lordship.
They are giving you in this beach.
Lordship, this is what they are trying to give, your lordship.
They are trying to give him in a beach. Huh? This photograph at page 188 is the beach. And does the river flood?
It's a sword, your lordship. I have been told.
They will have to pay. How can that be? Well, maybe, but then also one has to be reasonable. The state has to be reasonable, taking into account how can there be a Tozi Bahira? Once you are saying that Tozi Bahira is a penalty for staying in government land. On the other hand, you are giving an allotment. How there is the picture? Anyway, that is besides the point. The main question is now you say that you are going to give them some other place. Was this case sometime taken by me? No.
No,
This is a different one. No? And another APDCL where Mr. KP Pathak was also, that is same name.
No, that is from Sonic.
Oh, this is where.
This is support to me. Sickle money.
Now you are having what? Our Amel project given to whom?
land is allotted to APDCL, but then they will, your lordship. Then your lordship, some private parties will use it. That's what your lordship.
All are understood, but my question is, you have to give them a proper piece of land. Otherwise, wait till the disposal on stage. You have got an interim order.
Lordship, so far as we are concerned, we have gotten.
Wait. No, you see, you can't give them a land wherein obviously this is just going to flood and throw them out.
Lordship.
Give us, you file an affidavit to these allegations made about this land. File an affidavit that this land is not like this. First. Secondly, when you are asking them to move from one place to the other, you are giving a rehabilitation to them. If you are giving them a rehabilitation, give us a particular area. How many petitioners are here?
Lordship, here your lordship, 17. 17 petitioners are here.
Other writ petition.
In other writ petition, your lordship, there your lordship, 83.
And how many people are going to be affected? All may not have come.
No, your lordship, all have not come.
Yes, that is one. So those people who have been cancelled also, they are also may not have the source to come. So all these people, how are you going to do rehabilitate? You say that you are going to give them in a 200 bigger land. 200 bigger. But how it are going to give, which is the plot area, what is the plot and what are the plot sizes you are going to give? And against that, give them some settlement, some permanency to that particular thing. They will also go away.
Lordship,
They also are not against the power plant. The power plant, they will only get the electricity. Then why did you pass a speaking order saying that we are cancelling the allotment? These things won't work out. My question, therefore, is because the DC as well as you have to talk it out. First of all, file a reply as to whether this land is this. You may say that no, this is not the beach area. This is your question. That is one. Secondly, if they are being given an area for residing, they're going for giving for residing, there has to be some permanency. You are shifting them. Yes, we also want the power project to come. But when you are going to give them properly, not in a sense that tomorrow again you are going to throw them out somewhere. No, understood, but you have to give us something, then only I can give it. No. Back to means out here. Then they will shift from here. Tomorrow, if you don't give it, okay, we have all cancelled this speaking order. Those people who have speaking orders have been cancelled, all have to be given. Now, some people may not know, some people may not have the resources to come. All people do not have the resources to come. Yes, what do you say? No, first, my question is, Mr. Babu, the main question which arises out here is, why didn't you inform that on the day when the order was passed on 5/5/2025 by this court? That look here, they haven't already cancelled. You cancel it on 21/4. Order was passed on 5/5. Then when the order was passed in, this order must have been passed in oral. It doesn't look to be a long order to that effect. So if it is an oral order passed means that it was done in the court. Then it's an order. So it's an oral order which has been passed in the court. So it's a short order of 11 paragraphs. So you should have informed the court at that point of time. Who was the counsel appearing? Don't inform. How to do? No, that means understood. All these, if the speaking orders go, if the speaking orders goes out there, your notices go. Notices go means you go back to the stage of again issuing a notice for the speaking order, which will be again subject to again then for eviction. As of now, there is a permission.
Therefore, it was taking up my lord, double five. Double five, we have five it reduced to the figure. They are all the.
How many equations are there?
And they were also questioned by the decision of the CLAC to allot the land for power purpose.
No, you give a power protect, give a final reporter to that. What?
I indirectly that my lord, in page 289, the affidavit file, I don't know, 2355. When I get paragraph 9 and page 289, it is written, my lord, 2355, my lord.
Page?
355, page 89, running the 59.
Antibeva, why you have filed two
No,
requisitions?
your lordship, this so far as the second requisition is concerned, when these people came to know about these notices and others, your lordship, then they decided to challenge those laws. That's
Which one?
the cancellation of allotment. Your
Oh, these are similar. Okay. Now, what is the page you are referring to?
289. Perhaps this means we will have to, my lord, demonstrate more specifically.
Wait, yes.
289 is a part of my lord, paragraph 9, my lord, subpara. The deponent further begs to state that in an instant case, however, the petitioners have been given due opportunities to place their claims if any. So that means, my lord, the petitioners were heard. Now, how they were heard, this has not been demonstrated here.
Paragraph?
Paragraph 9. Subpara, my lord.
The deponent states that in the instant case, however, the petitioner have been given to place their claim. Claims for what?
Claims
They-
for for
You issue a notice.
settlement. Claims for settlement because they are seeking settlement over their plot of land itself.
No, they would go away. So you have to understand, they won't be there. They will be going away, but provide them properly.
So therefore, my lord, under that sort of yes. I got it, my lord. I take it.
It is a very, otherwise you are trying to go for a very arduous, long procedure. If you want very well, your power plant will be in 2029.
Now, yes, I got it. Yes. Now, so I had my
best option, your lordship, for them would have been, your lordship, to pay us compensation, your lordship, as per Land Acquisition Act. Because your lordship, Honorable Apex Court has also held, even in case of assigned land, they will have to follow the procedure
That means you have land.
No, that land, your lordship, so
No,
allotted.
no, do you
land.
have land?
No, that
My
allotted.
question
land.
is, do you have land?
No, that is that allotment.
The moment the compensation is paying, where will you go?
No, that your lordship, then no, your
That means
lordship.
you have land.
No, that is
Then
why
land
we have,
can-
no, we don't have the land.
We apply the Assam land.
No, no,
You heard it for the first time.
what, no.
People seeking land acquisition compensation.
I've never heard of
Deciding
that.
over
No,
government
no,
land.
not
Tomorrow I
illegally
will be the-
residing.
It's the
Tomorrow I
the
will be
moment
the
you
first
make
person
that
to go
submission
to
before this court, now I will take it on a different
No,
view.
no, no, your lordship, what I am saying is, your lordship, they
We do
could
one
have
thing.
done it.
Now we will do one thing. We set aside that orders, giving them the opportunity to issue a show cause, finish it up within 30 days. And pass speaking orders to the effect if they are violated. Then thereafter take action and we keep these notices in abeyance. After the challenging notices in abeyance for some time till you decide the speaking orders. Once the speaking orders are passed in their favor, don't take, you are passing a speaking order in their against them. Initiate proceedings for eviction.
No, your lordship will
Okay,
kindly.
you want money.
No,
you
I
go for
don't,
that.
lordship, that
I
your
was
lordship.
agreeing.
No,
No, Mr. Bothakur,
No, no,
this
your
doesn't
lordship,
seem
I
fair
have,
for you.
your
No,
lordship may
no.
kindly, no, your lordship may kindly see my
No,
affidavits, your
this
lordship.
is an order.
Your
best
lordship
order.
will kindly see my affidavits, your
No,
lordship.
no, I'm not going
No,
to see
I
that.
have never said, your
You are-
what I have
You see,
submitted.
rehabilitation, if we are looking into the
That is
question of
only-
rehabilitation, you don't have any right.
No, your lordship,
You don't have, you have given a government land. You
Lordship.
have given a government land only for permanent, not for permanent abode.
your
So
lordship,
therefore you are not entitled.
at the very first instance, your lordship, I have submitted this before this honorable court that I am ready to go, your lordship. Only thing, your lordship, they need to give us some land where habitable, your lordship. That is what my submission.
That is what I was also saying.
Lordship, that is.
Moment you are coming
No,
with the
that
land
is-
acquisition.
No, no,
question,
why?
don't come
No,
up with
your
that.
lordship, I have not prayed that, your lordship. What I have submitted, your lordship, they could have done
Don't
it
make
also.
that
That is
submission.
what I submitted.
You see,
Your lordship will
this-
kindly
this
see.
court have sympathy for the people who have
Lordship,
been
I know,
affected,
your
who are
lordship.
there.
I
But
know-
that
I
doesn't
know,
mean the moment you ask for land compensation means you have some other land.
No, your lordship,
And
that
if you
is.
have some other land, or because nowadays getting land
If-
compensation and buying land is also a difficult thing.
Lordship,
There's a land is scarce. You may not get an adequate compensation,
Your
but you are concerned about a area in a particular area
lordship.
where the land value must be much less also. Further to that, you don't have title over the land.
Lordship,
Your land is only of the value that you have been granted a possessory right
lordship.
for temporary conditional price. So the payment will be obviously less.
Your lordship may kindly see earlier orders, your lordship. We have specifically submitted that we are ready to go, your lordship. That is there, your
Let us
lordship,
keep to
recorded,
that.
your lordship. Only thing, your lordship, they are required to give us some land, your lordship.
Don't
where we
give.
can-
That is what I am trying
That's
to
it.
find it out.
That is
I'm
that is
asking
what
them
your
to file an
lordship.
affidavit to the referee.
We will finally join that
Give
to
us
the,
something to the referee
yeah,
that we did out. As to whether the land with the picture which have been shown out here are those lands in question, what? And if those are the land in question, then you have to think as to whether these lands are okay to the effect to give them so that tomorrow, the moment you are giving them, they are not tomorrow swimming out there in the land rather than walking on the land. One. Secondly, then you have to look into it. There has to be permanence to the. This is the form of compensation. Mr. Bothakur have used the word right to transparency. Instead of that, I use the word of permanent rehabilitation to be a form of compensation. But the compensation would be to the effect that you have to give permanence to where they are residing, to the land where you are going to allot. Giving hereby, you may not have to now, the amount of evictions you are carrying on, you may have to go not on tag numbers instead of the plot numbers. That is the only way out. You have to go into the plot numbers, which you find out there in our nature. They have this plot number. The plot number so and so how it is. You may not have that so many tag numbers. Plot number maybe one person will be there in this plot. And that day I said about that rehabilitation matter. Think about the partition of India. What happened?
file an additional affidavit bringing on record matter and clearly demonstrating the alternative plot of land that has been allotted, sought to be allotted for their rehabilitation with all the geotech coordinates in all detail.
Because I'm not going to.
Yes,
You see,
Yes.
till I'm not satisfied to the effect that you are the steps which are being taken by the state is in right harmonies, the matter will remain lost. Once I find it, yes, they will go ahead. Because my also, this court's also one of the basic thing is that the power department has to come out. Now, power is very essential everywhere. We are losing out on many aspects like the petroleum and all these things. We don't have this thing. The only way is either having hydroelectric in one of the avenues of energy or some other solar and all this is going to happen. So we have to. There's no quarrel with that. But we are doing it, do something good.
In the line of what in
Art
purpose,
mis-
affidavit.
Uh,
Clearly
As
demonstrated.
Mr. Exportaku, the level senior counsel assisted by Mr. S.D. appearing on behalf of the petitioner in the batch of petition. Mr. Agopudari appears on behalf of the Revenue Department of the Government of Assam. And Mr. Veena, the level senior government advocate, appears on behalf of the District Administration. The present batch of petition raises various issues pertaining to challenging the speaking orders by which the allotments which were granted to the petitioners were cancelled. Semicolon. Challenging the notices for eviction issued to the petitioners. And apart from that, etc. It is the specific stand of the state as it will be seen from the affidavit that the petitioners herein were granted temporary allotments, temporary conditional allotments, and were subject to temporary conditional allotments. These conditions earmarked in these allotments were violated by the petitioner. And as such, the speaking orders have been passed. Be it as it may, further to that, the state avers in their pleadings that in view of the speaking orders having been set aside, having been passed, thereby setting aside cancelling the allotments, the conditional and temporary allotments of the petitioners. Notice for evictions have been issued, taking into account that these lands have been re-allotted to the Assam Power Distribution Company Limited for setting up of a thermal power plant. This court takes note of an important aspect in the stand so taken by the respondent state to the effect that these petitioners would be allotted, would be granted rehabilitation in some other plot of land around 200 bighas, na? 200. Which admeasures 200 bighas. Mr. S. Bottaku, the learned senior counsel appearing on behalf of the petitioner, submitted then on verification, the land which have been mentioned is a land which is flood affected. And in that regard, have shown these pictures. So I have shown the photographs enclosed to the additional affidavit. The learned senior counsel submits that the state has to be fair and has to come up with the right has to come up with a better proposal so that the rehabilitation so granted to the petitioners is in true sense. Mr. Arboguzari in the learned counsel appearing on behalf of the Revenue Department submits that he would obtain instructions as to the condition of the land, in as much as he has no instructions in this, more particularly in respect to the affidavit, photographs which have been enclosed to the additional affidavits. He further submits that a detailed proposal will be placed before this court so that the matter can be proceeded with. Let's list this matter again on when?
Second week of August, madam.
On second week, it start the week only. First week is not there, August. The first week is only one day, that is closed. Third week. On 10th, 10th of August 2026. The affidavit be filed on or before 5th of August 2026. This court, before parting, would like to observe that while placing the proposal before this court by way of an affidavit, the respondents shall duly consider that when the petitioners are being sought to be rehabilitated in some other area, the petitioners have to leave the places of their allotment, where the petitioners have been residing for decades. Under such circumstances, the rehabilitation has to be in a true sense, and the rehabilitation should be done by keeping in mind that the said rehabilitation is in the form of a recompense to the petitioner for leaving the present places of their abode. Did not use the word compensation. Recompense.
If I could make a small submission, madam, that in that petition, paragraph 14, we have stated. It also makes an observation, madam, we will actually find the statements made in paragraph 14, where specifically stated, madam. That is WPC 3874. WPC 3874, paragraph 14. In the affidavit. Yes, yes. I take it.
Yeah, please, Lord. In this case, my lord, the brother of the deceased, my lord, has applied, my lord, for compensation because the brother has been killed by the wild elephant, my lord.
Wild elephant?
Yes, ma'am. Wild elephant, as per the final report, your lord, you will find at page 18, my lord. In the text and the relevant portion, your lord, you will find at page 19. Bottom, last paragraph.
Okay.
Also, there's one issue is here, Your Lordship. One issue is here that here in this representation, he has annexed an NOC from the wife of the petitioner, wife of the deceased. But
Why the deceased is not there?
My lord, deceased has got another marriage, my lord. Second time, marriage, my lord, the wife of the deceased. My lord,
He doesn't want.
my lord,
Kindly
your lord,
produce
will
instruction
find
for once,
that.
Your Lordship. Instruction which I have received. No next of kin certificate been submitted by him, Your Lordship.
My lord, as per notification, next of kin is not required, my lord.
You file an affidavit.
Very well, Lord.
Mr. R.R. Gogoi, the learned standing counsel of the Forest Department, submits that the Forest Department would like to file an affidavit in as much as per him, the petitioner hearing does not have the local standard to file the present. This matter again on 5th of August 2026 in the meantime.
if directed by the court, they'll file an affidavit in 18825. But my copy has not been served on us. So that was a common order. I served that. I served this thing. Let the copy of the affidavit to serve on us. Let it come after any other division.
I
They filed the affidavit. No, they filed, the government filed.
I have actually my junior student, damn lordship, boring. I can mistakenly, he did not give them. He has only given to the Dasar.
You don't want to be repaid.
No, lordship. Mistaken copy. Yeah, today, will serve lordship.
Fishery department, in the fishery,
Yes, lord.
you're doing well.
Yes, lord.
So therefore you have money.
Yes, I am fine.
The fishery department has filed an affidavit in opposition in which you put 188 of the 2025. However, no copies have been served upon. It is submitted that the said affidavit in opposition would be the common affidavit in respect to the other petition being the petition number 2051 of the 2025. Under such circumstances, it is the opinion of this court that all the represent all the petitioner as well as the private respondent, counsel for the petitioners as well as the private respondents should also be furnished copies. List this matter along with this matter again on when?
After 15 lakhs.
When is the period ending?
This is 7 years. 29, 32.
Okay. On 11th of we have it on 19th of August 2026.
Not like that.
The registry shall be on record the same.
How like that.
What is this?
We have filed our affidavit in 2936. As per your
Affidavit.
yes, lordship. And on 1st of June, we have released the earnest money which the petitioner has deposited along with it, with his tender document. And on 2nd of June, he has filed the case.
You have transferred to his bank account. He doesn't know you have.
No, that we have already an expert. Before that, another case is already pending. But that also. No, that
Now
case
they
is something different. That was on presumption that this case, this work will be allotted to any private party. And this is the case where he has challenged the work, lordship, the tender. The tender has already been cancelled and we have annexed this, annexure 4, page 104 now.
You are not filing your reply.
No, I'll be filing my lord. There, my lord, what happened, my lord? In their cancellation notice, my lord, they are raised on ground.
Mr. Counsel, listen. There is an interim order.
My lord, my lord.
You have to be serious in filing it.
Well,
You cannot say that I will file.
yes, sir.
We can allow you to file after 6 months also by vacating the interim. No. 2 weeks.
No, my lord. I'll be filing under the.
I have still 20 minutes left for Mr. Chaudhary's matter to be taken. So therefore, you can finish it off also. Because the affidavit has been filed, you don't file your affidavit.
My lord, they have filed my lord on 19
Yes. Mr. Ashok, the counsel appearing on behalf of the petitioner submits that an affidavit in opposition has been filed by the reports of the department and would like to file a reply. So Mr. R.M. Das, the learned counsel submitted the matter required urgency to implement on the bill that include order of rating. Considering the above list this matter on the 3rd of July 2006. From which date an attempt shall be made to dispose of the petition. The affidavit in reply be filed on or before 21st of July 2026. In term of the first earlier shall continue till the next.
Time of play.
That is it. That's already, I thought today my matter would be a long list, obviously, so I picked it at 4:30. By 12:31, I saw that my list will fall. Then I had to
Go slow.
slowly.
Can it be taken after the vacation?
Mr. Chaudhary, yes, I think your argument as of now would be on two judgments. One is on Sadar Amarjit Singh, whereby it brings in the other judgment, because that is a three judgments, why I'm saying. Which brings in the other judgment of what is the doctor Dr. Mita Sahai. Dr. Mita Sahai, you see, there is no constitutional bench judgment on local standard. All are three judges. Madan Lal is also three judges, except Muhammad Mustafa is two judges. All are two judges, except Muhammad Mustafa, which is three judges. Muhammad Mustafa deals with categorically as regards the local standing when you come. But in Sadananda Holloway, at paragraph number 40, it categorically says that, 39, it says that you don't, Lucas Pande is the thing, but if it is a case of malafide, it can very well come under section. That is paragraph. But this is the latest judgment whereby there was a divergence of opinion between Justice Bhanumati and another one. And this matter went to a three judges where I think it was authored by Justice Rishikesh Rawat. Right. Wherein he again said about this thing in the Kunta Sahai Church. And said, and then another aspect has been brought in, that if there is a violation of the statute, or if there or any discrimination on account of that violation, then obviously the report can take into account it and because the violation affects Article 14 and 16 of the Constitution, and resultantly, if there is a violation to Article 14 and 16, then irrespective of there cannot be a
Public law remedy can be invoked.
there cannot be a waiver to Article 14 and 16. And secondly, it also mentions out there that unless a person does not participate out there, how can he challenge an Article 14? The parameters are statutory violations or a discrimination on account of the statutory violations or malafide. These are the three lines
And most importantly, my lord, there cannot be any waiver of fundamental rights.
So that is why Mita Sahai.
Yes.
So this will be that I think
That is regarding, my lord, maintainability. On the other aspect, my lord, regarding that interview being the only mode of selection,
that I think I can't help you because
no, my lord,
19
no, my lord, I think the state is relying on Leeladhar.
No, not Leeladhar. 19.2 is the problem. That Leeladhar, the state will actually rely on the division.
Because Leeladhar wanted to basically explain, my lord, Khalid Mujib, Ajay Hasia's case. Because Ajay Hasia was a case which pertained to, my lord, admission to educational institution. And Leeladhar, my lord, where court was dealing with recruitment to public office. Therefore, court made a distinction saying, when it comes to admission to educational institution, because at that stage the mental faculty is not matured enough, therefore the interview component should be less, and where written test component should be more. Whereas in case of recruitment to public service, because in the meantime the person becomes mature, therefore interview is one of the best method of judging, the test. So therefore, my lord, to rely on Leeladhar and to say that
Mr. Chaudhary, what I see is the question as to whether Leeladhar could have been done or not is a question to be decided in the division bench, taking into account there the rule you are challenging it. Till 19.2 remains, there cannot be a written test because of the state of attention as Vibha was saying.
No, I'm not on that. Since before your lordship,
In fact, I was surprised why the matter should have normally when you challenge the rule, the selection will always be there.
Yes.
But the bifurcation being done, now the problem is I can't touch the rule.
Yes.
And with the rule, viva voce is there. The problem lies there.
No, but my submission is only to this limited extent. Even Rule 19.2 as it stands, but it has to be given a due meaning. The due meaning is there has to be an objective. But is it there? Now, my lord, only way to ascertain objectivity is to lay your lordship's hand to the records of the selection. I do not know what is the stage. End of the day, my lord, that satisfaction, it must be derived from some contemporaneous records. So these are the aspects, my lord, on which I will lay my emphasis. Well, certainly, since 19.2 is not under challenge, therefore the written test part I cannot even touch.
That is how it takes away. They have,
Yes.
though relied on Liladhar and all these things. I
Yes.
can't touch that.
Yes. No, certainly.
I can't go into that aspect.
Even that is, I will not make the submission, because my submission will be to persuade your lordships to take a view, even having regard to Rule 19.2, whether in assessing the merit as mentioned in 19.4 or 5, 6, it says, my lord, merit. When in 19.6 it refers to merit, that means, my lord, whatever procedure prescribed in 19.2 is to be followed. Now, their lordship will have to give a meaning how to ascertain that 19.2 has been followed. Merely because an affidavit is being filed and saying that no, everything was hunky-dory, that will not do, my lord. Therefore, our humble submission is, my lord, whether the selection committee, my lord, gave adequate time to each of the candidates, how the assessment was made. Eventually, my lord, it will have to inspire a confidence in the mind of your lordships. Because why I'm saying so, my lord, in Motilal Padampat, Honorable Supreme Court said, when it comes to giving power to result from a promise, court said no, it must be court satisfaction. Executive satisfaction will not do. Now, executive satisfaction selection is done. Now it is the satisfaction of the court.
But the satisfaction is limited in view of the Supreme Court.
My humble submission would be, even if when a selection is made purely on the basis of interview, there are certain aspects to be looked into.
Now, you have referred to that 97 judgment.
Yes, yes.
When it says that scientific and thorough investment method has to be. Now, whether the scientific and thorough is a question which you can very well, when you are alleging that it is the bounden duty of the state to respond.
Yes.
This is the
To be honest,
Chaudhary.
my lord,
Mr. Chaudhary, you may have seen it. I never take such a long time for a matter. I don't hear so much. I hear you and him and then finish our do the CAV and all, not much. This is a matter for the first time. You made one day argument. He made one day argument. This is again a reply, apart from that earlier time. So I have been getting so much of time for this.
so I would not like to trouble your lordships in the holiday. So on the reopening day, lordship will have this matter, my lord. In the meantime, I would like to go to one or two final aspects regarding this interview component. To be honest, my lord, yesterday I could not get time also. End of the day, my lord, the hard days nowadays, my lord, people are without employment, etc., etc.
But don't you think that this appeal being filed against the judgment and then taking along with that petition will help you on 19.2 properly? My question is this. Because you see, first of all, I was a bit surprised with the order of 28/1/2026 by the division bench. With due respect, and the blame has gone to you that Mr. K. N. Chaudhary has submitted to that effect that the completion of those, the exact words without
I
there.
have seen it. I know a lot.
So
And
because
that's
of that, now
suggestion
the
was never
problem
from
has
us, my lord.
happened. You see, I can't go. It means everywhere, the moment I try to deal with your submissions, everywhere because you get stopped. You see this. After some argument, Mr. Kiran Chaudhary, the learned senior appearing on behalf, agreed to the proposition advanced by this court that these two issues cannot be conflated as challenge to a select list to be effectively made with the learned single judge. This requisition has been posted before for the region so and so. We remit the matter before the learned single judge for deliberation on the issue of correctness. The challenge there shall be filed separately. So I think with 776. Because this, at the end of the day, the matter has to be decided as to whether Rule
Validity of
19.
the rules and Milord, these merits of this election ought to have been taken up.
No, because of the fact that 19.2 was integral to,
Yes,
because you have you may have a very good case of 19.2,
yes.
but without 19.2, you don't give this court any handle.
No, Milord,
My
correct,
problem
Milord.
is that.
Well, I was only trying to look at it this way, this perspective, Milord. I'm also conscious of the fact, Milord, for 226 code or power of judicial review can extend to how much? Or to what extent it can stretch? That we're conscious. But within that limitation, Milord, there are some gray areas. So I would like to exploit that. Only thing is, Milord, let the matter be taken up on the reopening day, Milord. I'll address your lordship. Lordship will kindly give me half an hour time at 3 o'clock. I'll conclude on that. On 13.
But otherwise, I have made your, as I was saying, I've been, what do? I don't have CABs. So when I go back, so what I do, I first make I have already noted down the facts, your submissions with the DSHS submission. And also I have put your reply also submissions to the effect, although not made,
It has
the
been
effect.
structured, Milord.
You see, you have to structure it because later on again you will forget it to the
Yes.
effect. I put those two judgments, Mitasa and so, and that Sadar so and so, to the effect that because nobody submitted about Sadar judgment. That is the three judges.
Three judges.
It's a three judges in the latest judgment on the point of this respect. Now, these three judges judgment out there.
Sukhmander Singh.
Huh?
Sukhmander Singh.
No. That is two judges.
No,
I'm
three
saying
judges, Milord. Rishikesh Roy.
No. That is a different judgment. This is a different. You see, I'm saying about this judgment. Wait.
Rishikesh Roy judgment.
No. Salam Amarjit Singh.
Oh, one second.
There was a reference which was made.
Okay.
That is 2016 10
No, sorry,
SEC 4.
Milord, I have-
No, you have not.
Hmm.
This is the latest judgment on Dr. Mita Sahai.
Uh-huh.
Is a two judges judgment.
Yes.
If you see all the judgments which are there,
All by two honorable judges.
except Muhammad Mustafa is. Now, this is the only other side judgment of three. The Salam Amarjit Singh. I put that also in your argument. Because this is a very important issue, Article 14 and 16.
Yes.
Because Article 14 and 16 cannot be waived.
Yes.
Cannot be waived. But again, the problem is the parameters on which you can waive is only limited by those that Mita Sahai
I think
and Sadananda Holloy, paragraph 40.
also would like to also have a look at Processor now on Milord that there can be, that's the first judgment of this. I think that is of 1964. The Processor now versus State of Punjab regarding non-waiver of fundamental rights.
No, that is okay. Because there is another judgment, another three judges judgment of 1957 also on this point, which goes against you. That is another point, but this is the latest because Madan Lal brings in 57 judgment pertains to selection proceedings where on the question of bias, he did not raise that issue. He participated. He had thought that this person was there. You had more. The facts were more raw to the effect that this person thought that I will get a good recommendation from him. He participated. Later on, came to know that this person knew the other fellow more. So he said bias. Now, therefore, the Supreme Court said no, nothing doing.
And Rajkumar Raj Sakti is also another case.
That is the judgment of 1997, 8 SCC.
Our High Court judgment is there, police constable.
Yes.
Muslim Ali. No, no. Surround the Supreme Court, single judge.
Because after 95, that judgment of 97, 8 SCC, if I'm not wrong. Last,
Quite some time,
it was there.
holding the field for quite some time.
The hearing could not be completed, least the matter came on when,
It can
16th.
admit on 13 or at the lordship.
13th is Monday. On 14th,
15
14th,
Okay.
on 14th at 3 p.m.
Well, I'll just take half an hour time at 3:30 or 3 o'clock.
Yeah, what is there? You want to also? You also? Ah, that is your submission. No, I've noticed that. You notice how you have referred to two judges. One is Pradeep Rai and one is some K starting with K. And in these two paragraphs, one is by Justice Ranjan Gogoi, and there was another judgment by another one. So this is the two judges bench, the other one. That is your. Then you say that your submission is 8-4, only categorically mentions to the effect it is not a disqualification. It is a case by which one has to submit the self-declaration. The self-declaration, there is no allegation that you have not submitted the self-declaration. And on the other hand, you say that you have submitted the same.